two, 1, 2. Testing 1, 2. Fungile, can we call Jane? I don't think she knows that we are starting the meeting. I wish to welcome everyone. I would like to also apologize. Already it's 10 minutes past 9. Last time we also apologized. We really don't want this and don't like it, but it's reasons that are unforeseen. The technology is advanced and we were born before the technology, which we are really apologetic about that. Thank you very much. Let me welcome everyone in the meeting and say that we wish to discuss as much as we can today in terms of the Children's Amendment Bill, which we hope that it's our last day to finalize this according to the Gauteng High Court judgment. We've been discussing this now and again, and we hope that everyone in the virtual is also able to hear us. The stakeholders are also welcome, NGOs, different ones. The officials are also welcome. That is the backup support from us. We also want to welcome the gurus. I always call them gurus, the advocates that are present with us today. A special one to the honorable members. I understand that our hands are full with lots of responsibility, but as social development members, we avail ourselves at all times when the call has reached us. So I wish to welcome honorable members once more. You are showing the dedication to the committee, and I know that you want this bill to be finalized and finished, but with the inclusive of the stakeholders present with us. We understand we had to adjourn the meeting, the previous meeting, because of the glitches that we experienced, and also the sound, the technology couldn't allow us to continue. That's why we requested to meet today again. So thank you very much, honorable members. Let's request Lindy, our secretary, to flight the agenda so that we are able to continue with immediate effect. There is the agenda, honorable members, flighted. We are at Taj Hotel. I have forgotten because since I'm in Cape Town, I think we are in the parliament, but we are in Taj Hotel. The apologies. I've done the welcoming. I can't waste time already. It's wasted. The introduction by the MPs. Let's request Lindy just to do the attendance and confirm it. Thanks, Lindy.
Good morning, members and stakeholders in presence. I wish to confirm the following members in our midst. We have you, Member Mvana, as the chairperson of this committee.
Myself.
We have Member Stock next to. We have Member Masango. We have Member Mare. We have Member Abrahams. Next to Member Mare, we have Member Sukars.
Thank you.
We have member Opperman,
Thank you.
and we have our legend member Mangani.
Veteran. Thank you very
Present.
much. You know why I'm requesting you to raise your hand? Because this has been, in fact, this is visualized. So you are not greeting to me. I've already greeted you, but you are greeting the communities, the stakeholders, the officials that are with. Thank you very much. Yes, thanks, Jane.
Chairperson,
Chairperson.
sorry,
Yes,
Yeah, we are
Bilangulu.
also on the virtual.
Who's that? You have
Honorable
been
Ice.
you have been mentioned. We can again mention you. We do have Honorable Aris on the virtual. We also do have member Kate Bilangulu on the virtual. Are you able to raise your hands? And Honorable Lizelle van der Merwe, they have joined on the virtual. Can we see you, honorable members?
Thank you, Chairperson.
Thank you, Chair. We are here.
Okay. Honorable Kate.
Chair, just to report that I received 2 apologies as the standing one from member Mutaung due to ill health, and member Bilangulu, she's got terrible flu, so she's also not with us today. Those 2 members, apologies, Chair. So I've covered an apology item. Thank you very much.
Thank you very much, Lindy. We hope that my executive secretary didn't send an apology to you, Thandi Mahubulele, the one who was with us last time. Then can we then give over to the one that are present today to introduce themselves? Over to you. Sinibuke TV.
Good morning, honorable members. Luyanda Mchochisa from Social Development. Thank you.
Thank you.
Yes, good morning, honorable members, and good morning, Chair. My name is Nkosinathi Dladla from DSD Legal Services. Thank you.
Thank you.
Good morning, Chairperson and members. My name is Natim Jenglane. I'm a parliamentary legal advisor. Thank you.
Thank you, advocates and representative from the DST. Lindy, you have forgotten something?
Yes, Chairperson, I forgot to mention that our content advisor, Yolisa Kanye, will join the meeting a bit late. She has a doctor's appointment. Thank you very much.
Thank you very much, Lindy. Okay. I hope and I think we have to adopt and accept, in fact, not adopt as such, but accept the apologies, especially the written ones via the secretary. But let's give over to the DST first so that we do it. Not deputy minister. Okay, let's give them. Can we give over to LinkedIn? Over to you, LinkedIn.
Thank you very much, Honorable Chair. Very good morning to you and good morning to all honorable members and participants in the meeting. Mine was to render the apology of the Minister, Honorable Chair. She is out on official duty at the moment, out of town, and therefore I'd like to render an apology for her. I think our Deputy Minister is also not able to attend the meeting this morning, and I wanted to also render an apology on her behalf, Honorable Chair. Thank you very much, ma'am.
Oh, what about the DM?
Chairperson, I've
Excuse me, Lindy. LinkedIn, do you know anything?
Chair, I think the DM is not able to join us this morning. I know she was missioned in KZN. Let me just double check with her office very quickly.
Okay,
Chair,
before double checking, let's give over to Lindy. Seemingly, we are behind the schedule. Let's give over to Lindy. Lindy is having the apology for the DM.
Apologies, Chair. I omitted to mention that I've received an apology from the DM's office indicating that she won't be able with us today due to private commitments. She has been deployed to KZN to look at the issues of the disaster. Thank you very much.
Thank you very much for that decent apology written down. Then let me give over to the honorable members to accept these apologies, especially the ones that have gone through the right procedure in terms of Honorable Mangani. Accept the apology.
Accept the
Honorable Mangani, accept the apologies. Honorable Mare. Honorable Mare seconds the apologies. Thank you very much. Then let's proceed to the adoption of the agenda, honorable members. The next item is the adoption of the agenda. Flight the agenda, Lindy, so that they can remember on what is it that is on the agenda.
Okay, Chair.
There is the agenda, honorable members. It's finalization of the presentation by the department. It's parliamentary legal advisor. And then where is the state law advisor? Is it there? It needs to be there just to say they are with us or whatever they want to add, whatever that they need. We have to put, and then the deliberations. Can we then adopt the agenda as it is and amend it? Honorable Mangaji?
I move for the adoption of the agenda with those
Yes,
amendments of
amendments.
the state.
Thank you very much, Honorable. Honorable Stock?
Thank you very much, Honorable Chair. I second the proposal for the adoption of the agenda. Thanks.
Honorable members, the agenda has been adopted. Can we then, before we go straight to the parliamentary, in fact,
Recording
to
in
the
progress.
can we, in fact, let me announce that the breakfast will be served downstairs. Ne? So we had to break somewhere sometime before 10:30. We will see on how far we go with this because we have started late with 15 minutes. So when time is okay, I will request honorable members to quickly grab and just be fast and come back, because today we wish to be the final day to finalize and conclude this bill. Can we then give over to Advocate Chochisa, the DSD Singani up? So can we give over to you? Last time we got the presentation from the parliamentary, but just to go through and remind us, browse through and get on the business of the day. Over to you. And be ready, parliamentary advisor.
Thank you, Chairperson. Good morning once again, and good morning, honorable members and colleagues. You will recall that last time we made a presentation relating to the clauses of the bill that needs to be taken out from the main bill and form a new bill, which will be focusing only on foster care, which is the 12 clauses that we outlined last week. Now we are presenting the metrics in relation to those clauses in terms of what the communities had said out there when you went around as Parliament to solicit public hearings. As we indicated that indeed those clauses that we have identified to be in line with the foster care North Gauteng High Court order were also part of the bigger bill. So comments were made when Parliament was going around. The first one is in relation to clause 1A. Oh, okay. The first one is in relation to clause 1A of the bill, where there is a need to insert or amend the new definition of an abandoned child in order to fit in with section 151A of the Act, so that it falls in the context of a child in need of care and protection. We indicated as a department that yes, we agree with this proposal, which was mainly from the Center for Child Law, Professor L. Skelton, and a variety of other stakeholders. So in the extreme right of the metrics, that is where we have indicated that this is how we will have to deal with this particular definition in the new bill that is proposed. You will see that we have indicated, yes, that the bill needs to be amended so that we define the abandoned child in the context that is outlined in the metrics there, that is on the extreme right. Which we will see in the new version of the bill when we discuss it further as we progress with this. Again, honorable members, we had indicated that there was a need to amend clause 1E of the bill, which is a definition of a caregiver, and the department had indicated that in this regard, yes, we agree that the definition of a caregiver has to be amended in order to take into account a person that is assigned care of a child within a registered cluster foster care scheme, and also to take into account the issue of grandparents or adult siblings or half siblings that are staying with a particular child. The particular child to be part of the caregivers. Again, honorable members and honorable chairperson, there was a need to amend the definition of, that is 1H, definition of cluster foster care scheme, where the department indicated that with regards to this, the department disagrees with the proposal, because the proposal was that there is a need for the inclusion of district offices or local offices in the implementation of the provision itself. And we disagree because we are saying normally the legislation itself is not concerned with the operational matters. The issue of district offices and local offices are already catered for in the entire legislation in terms of the delegation of powers, because the MECs, the HODs are given the power to delegate the power to any official in the department, meaning that in that way, the district offices and the local offices can indeed have that kind of power. Again, honorable members and honorable chair, there was a proposal by the Western Cape Department of Education and all other stakeholders mentioned here in the metrics in terms of clause 24, which is about the extension of the jurisdiction of the courts, that is the magistrates' courts. You will remember that we had indicated that the jurisdiction of the children's courts have to be extended in order to cater for the issues of guardianship. So the rationale for this particular provision is to amend the jurisdiction of the court. So the proposal was in line with the consequential amendments that we need to take into account. Hence, we have agreed to the amendment of this particular clause. You will see on the extreme right of the matrix, the mentioning of section 45B capital A and 45(1) B capital A, where the issue of guardianship has to be taken into account, because in that way we will be addressing what we have already proposed in terms of extending the jurisdiction of the courts. With regard to section 56, which is one of the sections we had said we are also going to take into account for foster care purposes. There has been a comment from the Western Cape Department of Education and Center for Child Law. One from the Western Cape Department of Education has been around the amendment of section 145 to indicate the issues of quality assurance. That is the inclusion of quality assurance for child protection services and not only child protection organizations, of which we have taken into account that, and we agree with that as a department. And also the Center for Child Law also made a comment around section 1054 indicating that it should read as that the designated child protection services social worker in the service of a child and youth care center. And we have supported the definition, and on the extreme right of the matrix, we have rewritten that in order to cater for the suggestion by the or the proposal by the persons who made comments around that. With regard to clause 77, we had to amend section 142 of the Act in order to empower the minister to make regulations prescribing the powers and duties and responsibilities of the registrar of the National Child Protection Register. There have no proposal with regard to section 291 of the Act, but with regard to the Limpopo Greater Zanin, who also made comments, we have noted the comments, but the comments themselves are in line with what we have proposed in the Act. They are not necessarily saying we must change that which we already have in the bill. So we have taken note of the comments and we retain the clause as it is. With regard to section 82, which seeks to amend section 150, there has been a proposal to amend section 151A to also read to include a child who has been abandoned or orphaned and is not in the care of a family member as defined in section 1. You must remember we had said in the beginning we want to amend section that is clause 1A to deal with the definition of an abandoned child. So this must be read together with that definition, and because of that there is a consequential amendment in this particular regard, and also the proposal that is being made here. And we are saying as a department, yes, we do agree, we support, but we have to modify it a little bit so that it suits the circumstances. And on the extreme right, in the new bill, you will see the insertion of the proposed amendment, which will read differently from what it is currently. Again, Honorable Chair and Honorable Members, with regards to the other clause, which is clause 83, which seeks to amend section 155 of the Act by effecting consequential amendments. There have been comments from Child Law that have been received in line with the amendment of section 155 subsection 1 to read without the words a children's court must decide the question of whether, and then the inclusion of what is underlined in that particular column. Then we support the proposal as a department. And on the extreme right, that is where we have the proposed version of the clause, which we will see in the new bill that we will be having in after we have taken into account of these clauses. With regard to the other clause that we also took into account, which is clause 84. The Center for Child Law also made comments around this, and we said with regard to clause 84, as a department, the proposal that is made in terms of section 156(1)(e)(2), that the department does support the view, and will need to rephrase clause 84 with regard to foster care with a registered foster care scheme. So the definition of a caregiver will be a caregiver who is a person assigned as indicated in this particular clause. So there will be an amendment in that particular regard. So the department does support the view. Again, Honorable Chair and Honorable Members, there has been a proposal that we amend clause 85 to deal with the issue of clarity, because the current version is talking about a very young child, a very young person, and then there has been a confusion in terms of what that exactly means, and then that has been dealt with. So the proposal has been accepted in that regard. And on the extreme right, that is the column of the matrix on the extreme right, is the new version of how the proposed clause will look like. With regard to clause 86, which seeks to amend clause 159, there has been a commentary from a number of persons, from Professor Ann Skelton, Give a Child Family, Children's Institute, and the likes. And we are saying as a department, because what they are actually saying is that there must be an amendment of section 1592 A to read for 3 years from the date of commencement of this act in relation to orphaned or abandoned children in the foster care with family members. Actually, the proposal here is not accepted as a department, because we are saying when you read section 48 of the act, and the courts have already been given a power to extend these orders for a period of 6 months. So we are not changing that as part of this proposal, because the legislation is already catering for that. The 3-year period is 3 to 5 year period that is being suggested is not going to assist in dealing with this particular matter. Again, with regard to the other amendment, which is clause is it 92, clause 92, which seeks to amend section 183 by effecting consequential amendments. We have taken note of the fact that there has been no comments in this regard, but it is also important that we have this particular clause in the foster care proposed bill with all the reasons that we have advanced during our previous engagement. With regard to clause 93, which seeks to amend section 185 by providing for a number of children that must be taken care of on the foster care system within a family environment. There has been no proposal in this regard, and we have kept it like that, and we will be having it as it is in the bill that is being proposed. So basically, honorable members and honorable chair, this is the response that we are giving to the commentary that has been received from the public hearings that you engaged as the parliament. And we are saying there are areas where we agree and there are areas where we don't agree. In fact, where we don't agree, there's just minor circumstances. Otherwise, the bulk of the clauses, we are in agreement with regard to that. And with regards to the last one, which I've almost forgotten, the clause, that is clause 94. We are saying the department does not support the view of the amendment of clause 94, because this is about monitoring of the whole foster care system. And we are saying this whole system needs to be monitored in order to ensure at the end of the day that there is compliance and then there is no further backlog moving forward. So the department retains this particular clause. Thank you, Honorable Chair and Honorable Members. That's basically the clauses in response to the public hearings that you went for around the country. Thanks, Honorable Chair.
Thank you, Advocate Nchochisa. Honorable members, remember last or previous meeting, we were awaiting for metrics to be presented to us. Now the metrics are being presented by Advocate Nchochisa. Let's also give the parliamentary advisor on the metrics.
a synopsis of how the bill would look like. It was a deliberated.
Oh, okay. I don't, Lindy is whispering something to me. Can we also give over to you before you, Advocate Mjenxa?
My apologies for that. Honorable Chair and honorable members, the indication is that maybe we need to also flight the bill. That is the newly proposed bill, just to see how it looks like and what it caters for. And we finish with that kind of a presentation. And after that, we can take the questions relating to the bill, the presentation we made last week, and this particular presentation. If that is okay with you, Honorable Chair and honorable members.
Yes, there's no other way. We have to finalize
And that will be an Annexure A.
Annexure A.
Of the bill. So, Honorable Chair and honorable members, you will see that following from what we agreed upon with the legal advisor from Parliament and also the state law advisor, we came up with a bill which seeks to be a bill that will be dealing with foster care clauses only and in response to the North Gauteng High Court order. And this bill begins with clause 1A, which I've just spoken to in relation to an abandoned child. So it addresses that. And the kind of a bill that you are looking at now is exactly the bill. It's exactly the bill as it was published for public comments by Parliament. Okay.
Okay. Yeah, we don't see, I've just requested a person who's responsible for this. It's Blair. The only thing, if one doesn't have a copy, really you will struggle to see it from the screen. I don't know what's happening.
Can you make it bigger?
It's
Yeah, at the bottom there. At the bottom. Yeah, plus, yeah, plus, press on plus.
the bill itself. We do have it. Yeah.
Yeah.
Izamile, it's better now. Okay, it's better.
It's better. Yeah. It's worth it. Yeah. Okay.
Okay,
Is it much better now?
it's much better.
Okay.
But I was also perusing from the iPad. It's really difficult to see it. Fine now. It's fine.
Okay, thank you,
Thanks.
Honorable Chair. So that is clause 1A, which will be having in the new bill, which will be addressing the definition of abandoned child, also the definition of caregiver, and also the substitution of the definition of cluster foster care scheme, as we have indicated that we'll be dealing with three definitions as per the current bill, because remember the current bill is going up to Z, if I'm not mistaken, clause 1A to 1Z, but this one we're only taking A, E, and H for the purposes of foster care. And also there is clause 24 that we are also amending, which will be the new clause 2 of the bill. I hope I'm not fast, Lindy. That is clause 24, which will be, down, yes. So I'm trying to say, if you've got both bills with you, just to follow the sequence of events and how these unfold, you'll see that there's an amendment for section 45, which is clause 24 in the current bill, but in this bill now, that clause 24 will be our new clause 2, which will be addressing the issues of guardianship, And again, clause 56 in the old bill will now be clause 3, which will be dealing with issues of quality assurance that must be taken into account. And clause 74 will be the new clause 4 in terms of this particular bill. Clause 82 will be the new clause 5. Oh, okay, I'm sorry. Oh, my apologies for that. Clause 82 will be the new clause 5. And then the clause 83 will be the new clause 6. Okay.
Honorable Mat.
Sorry, Chair, I don't know if the rest of the members are able to keep up with what the legal advisor is saying, but I am certainly getting lost because we have our document in front of us and he's going through that one. So I don't know if I'm the only one that's getting a bit lost with his summation.
Do you have your initial bill?
I have both in front of me. I have the new one that was given to us last week and I have the old one.
No, the real one, that old one that you were given, like this. Yeah, that one. Do you? Hey, that one.
Yeah, last week.
Are you here last week? It's not for last week. It's that old one that we were given. Yeah, that one, the original bill. He is presenting the original bill. And it?
No, last week's one. That's a B version that we're going through.
Which last one, do you know?
Remember, members, last week we distributed 3 documents, the foster care document and the presentation, and there was also a bill, a smaller version. This is the B version of the bill when we agreed on it. So he's taking us through that version just to have an insight how would it look when we agreed on it. So it's a smaller one. Maybe I can ask for me to quickly make copies.
Come and Bonnet, Jay. I know it's not that one. It was sent to us by email or post. Yeah, it's on email and also by post. It's sent to us. Can you send to members right now so that those ones, because it's going to take a time to go in. You do, oh, you okay. Ikopi. Jane doesn't have a gadget. Kasithumelele ndizamnika i-gadget le. It's 10, it's 10 to now. I'm sorry, thank you. Quickly go for a break, 15 minutes. 10 to now, sibuya nini ke? 5 past. Okay, so that we also wait for these copies.
Recording stopped.
Backup. Media people also invited. Asingeke simtshele ngokwethu nodolo wethu. Eyami ifikile yasi. Yo. It's just that time is running very fast. Honorable members, we have to reconvene now. Are the stakeholders with us? Can I get that indication?
If you are smart,
Is it Paula? Bani Omnyolo? Paula, are you with us?
much as he can.
Thank you to hear you. Honorables Aris and Honorable Van der Merwe and Honorable Kate, are you with us? Are you with us, honorable members? We have to reconvene.
Recording in progress.
Honorable Aris. Honorable Van der Merwe, are you with us?
Would you please let me in?
Please put her in. Thank you very much. We have to reconvene. Honorable Stock is coming. Thank you very much, Fungile. You've been so good. I know it's not an easy thing. Let's go back to you, Advocate Mchochisa.
Thank you, Honorable Chair
Buka.
and honorable members. We're still busy with the bill when we broke for tea. We were indicating that this is a new version of the bill, or how the new version would look like. That is having taken the clauses from the existing bill and putting them in one bill. And then the bill we'll be discussing moving forward. We have not effected any changes for now, as Parliament will be working on that. So we're saying we also have clause 83, which will now be clause 6 in terms of this particular bill. That is, it will be clause 6 amending section 155 of the Act, and also clause 84, which will be the new clause 7, that is amending section 156 of the Act. Again, we'll have clause 85 being the new clause 8, which is amending section 157 of the Act. We also have clause 86, which will be amending clause 9 of the Act, and also clause 93, which will be amending clause 185, as well as clause 94, which will be amending clause 86, being the new clause 12 of the Act. So basically, this is how the bill will be looking like. And you'll recall that the commencement clause and the short title in the bigger bill is clause 147. And now that will be clause 13 in terms of this particular Act. So basically, Honorable Chair and honorable members, these are the 3 documents that we have presented to you. That is the presentation that we made last week, the presentation based on the matrix, which we have just done, and also this small version of the bill, which encapsulates the provisions that deal with foster care only. So basically, that is what we have as a department. I think I must pause there, Honorable Chair. Thank you.
Oh, thank you, Advocate Mchenga. I think it's clear for us, honorable members. The first number is the one that is being amended, and the second number on the same line with that one, it's the new number that has been amended, isn't it, Advocate?
Correct, Honorable Chair. Only in as far as from 2 to the last one. Otherwise, the first one is the same as the in the broader bill, because it's clause 1 even there. So there is no change with regard to the first one, because it is clause 1 even in the bigger bill, but the subsequent ones have have shifted. Yes.
have shifted their numbers.
Thanks.
So we're able also to read it. 84, clause 84 is 7, according to this. We will be able also to explain to people and to communities now. Otherwise, it was not easy for us to read in terms of 93. You don't know whether to say 93, what. And then 54 or 94, what. Ubona nje ama-brackets. So at least it's better for us now to read it and explain what does it mean. Thank you very much, Advocate Chochisa. We are about to give the parliamentary advice. This is according to its B list. B bill. Okay. B bill. Are we together, Honorable Abrams? Okay. Mary? B bill. Honorable Masango, Bridget. I'm
Okay, Chair.
comfortable with Bridge.
Yes, indeed. Chair, when the advocate was going through, like saying 92, 10, whatever, the 92 was not mentioned. He went from 86 to 93, or not? Which is 92, which is changing. Yes.
It must be an ovation of on my side,
Oh,
honorable
okay.
member.
So
yes,
it is
it is there.
Yeah, it's there.
Yes,
Thank
I
you,
just skipped it
Thank you,
by
Chair.
mistake. Thank you.
Now, according to the hard copy. Lapha in second last. Mbonise lapha kwi gadget. Kaloku u-86 will follow u-92. 86, if you are from 86, you'll get to 92. Are we together, Honorable Ma'am? Are you covered, Honorable Meje? Okay. Then what's next now? According to the procedure and process, we are on B bill, eh? Hey, kunzima. Kwenzeka ntoni ngoku after this? Yes.
No, thank you, Chairperson. Chair, just to correct the procedural terminology and assist members. So what the members were looking at now, which was presented by the department, is what the B version is going to look like when we get to it.
Oh, we haven't managed to get
we
into.
haven't gotten there yet. Chair.
Oh, we are still going to B version.
Yes, Chair, but we'll start with the.
We're still on A version.
Yes, Chair.
Oh, I'm so good. Okay.
So in essence, Chair, what members are looking at now are the 12 clauses which we agreed on as the interim foster care provision that's going to respond to the North Gauteng High Court judgment. We have just simply done now what the department was presenting, taken directly from the bill as introduced and put on a separate document, only those 12 clauses, which the committee has directed we must do, which are the clauses that are going to be responding directly to the North Gauteng High Court judgment. That's what the process is now, Chair. Thank you.
It means then you are done from your side now.
No, I must start on my side.
Okay, can you go straight to?
Thank you, Chairperson. So, Chairperson, as I have already mentioned, the committee had requested us, the parliamentary legal advisors, to work with the state law advisor as well as the legal advisors from the Department of Social Development to go and look at the bill and see which clauses, after the committee had taken the decision that it wants to mainly focus on the North Gauteng High Court judgment, the response thereto. We were then requested to go and look into the bill as introduced and see which clauses in the bill would serve to respond adequately to the direction of the North Gauteng judgment in its order. We then agreed amongst the three of us, Chairperson, with our colleague Lisa Naidu, who's a state law advisor who was present in the meeting, who was joined the meeting virtually. We agreed that the 12 as presented by our colleague Advocate Mchochisa now are the 12 clauses that would adequately respond to the judgment. So that's the first thing, Chairperson. And Chairperson, what we had to look at as we were analyzing which of the clauses would be relevant was to see whether those 12 clauses would serve as an inquiry into extending the subject matter of the bill. But we were then comfortable, Chairperson, in our analysis that these 12 clauses that have been presented now, or these 12 clauses do not in any way extend the subject matter of the bill. And therefore, there is no need for the committee to seek the permission of the Assembly or the House as it would if these 12 amendments were extending the subject matter of the bill. And also, Chairperson, we're quite comforted in our analysis that these 12 clauses do not change the classification of the bill, in which case the committee would have had to go and consult the joint taking mechanism on the change of classification, because that would have meant that the bill will be processed in terms of a different section in the Constitution than it has already been tagged. So those were the key issues that we looked at, Chairperson, as we were coming up with these 12 clauses as presented by the department. But today, Chairperson, my task is to present to the committee on the steps to be followed by the committee from here on, having made the decision that it wants to mainly focus on these 12 clauses. So, Chairperson, I just want to state that this process is a process informed by Section 57 of the Constitution, which gives the committee, authorizes the committee to determine its internal arrangements, proceedings, and procedures. This is also supported by the National Assembly Rule 167, which also gives expression to that Section 57 of the Constitution. It states that a portfolio committee has the power to determine its own internal working arrangements. And in that regard, the committee has made the decision, following the guidance of those two sections in the Constitution and in the rules, to decide that it wants to take the bill as introduced, amend it such that it only provides for foster care and respond to the North Gauteng High Court judgment, and keep all of these other issues that are presented in that bill or provided for in that bill in abeyance for a process separate from that which focuses on providing for foster care as directed by the North Gauteng High Court judgment. So, Chairperson, in terms of 286, which is the National Assembly rules, again, Chairperson, that guide this process in the committee. The committee has taken this decision. It's going to be amending the bill. And the amendment of the bill really is to simply take from the bill, extrapolate those clauses that deal with foster care parenting, and leave the rest to be provided for in a process which I will later explain, Chairperson, as I'm presenting, which then leaves us with the 12 clauses which Advocate Mchochisa has just presented, Chairperson. So mine, Chairperson, is just to emphasize that this is a process that is set out in the rules, which has been followed by the committee up to thus far. So the next step now, Chairperson, would be for the committee to deliberate on these 12 clauses which have been presented, to determine whether these 12 clauses are satisfactorily for the committee, or in other words, properly and duly capture the committee's decision of focusing only on providing for extensive foster care parenting as directed by the North Gauteng High Court. So that's the next step, Chairperson, it's deliberations of the committee. We will then, Chairperson, after the deliberations of the committee, because we are part of the process as legal advisors, are going to be looking into how we can assist the committee to capture any amendments from these 12 that the committee would like to come up with, so that we can draw up what is known as the A list, Chairperson. So the A list, in essence, Chairperson, is a list of committee amendments. This is where, Chairperson, the 12 that was presented there by Advocate Mchochisa is already the list of amendments that the committee wants to see. The next step now is to see whether the wording of those 12 suits the committee or properly responds to the judgment as the committee has directed. Subsequent to which we'll go and draw up a formal A list for the committee, which we'll present to the committee. And subsequent to us having presented the A list, after having taken it to CREDA, our service provider who does the typesetting for us, the formal bill, we will then present that A list and the committee will then take the next step from the committee to the B version, the so-called B version that we're talking about here, which is a version of the bill as introduced that includes all of the changes or amendments that have been effected by the committee. So the B version, Chairperson, is the final bill that will see that will become an act. The committee will consider the B version, which will present to it to see that we have properly captured its amendments. Subsequent to which a committee report in terms of the National Assembly Rules 288 must be developed. The committee report will capture everything else that has taken place in the committee, including the decision on this amendment of the legislation. That report, Chairperson, will then be attaching the bill, which is the B version, and taken back to be reported on to the National Assembly or the House. That process, Chairperson, involves the publishing of the bill as well as the report on the ATC, which is the publication within Parliament, and subsequent to which there will be a second reading in terms of Rule 290, Chairperson. Second reading is when this bill is being debated in the House together with its report, Chairperson. Subsequent to that process, then the bill will be referred to the National Council of Provinces for the second aspect. That is the process, Chairperson, that is to be followed henceforth. Thank you very much.
Thank you very much, Advocate Gentleman. Hey, it's still a long way to go. You. And then, can we give over to the state law advisor? Is she present? Can we get an indication whether Ms. Naidu, please, are you available?
I'm available, members.
Over to you.
Thank you, Chair. I am in agreement with everything that my colleague, the parliamentary law advisor, has indicated to the committee, that we did work together with the department to formulate this 12 clauses. From the state law advisor's side and together with the parliamentary law advisor, in addition...
Hold on, Liz. There's no sound. Honorable Kate, Honorable Van der Merwe and Honorable.
Very clearly.
Okay, who is not hearing us? Or you sent it a message before. Thank you very much. We are still on A list, ne? You had the procedure and the process that we're going to follow. Honorable members on virtual.
Yes, Chair, it was very clear. Thank you.
Thanks, bye. Carry on, state law advisor, Liz.
Thank you, Chair. Just to add to what the parliamentary law advisor had indicated, from the state law advisor's office and the parliamentary law advisor, we need to ensure that when the bill is being processed, it's constitutionally sound in terms of procedure and substance. And just to indicate to the committee that these clauses have already gone through vigorous public consultation. So that constitutional requirement has already been met because there hasn't been any new clauses that the department has introduced in relation to foster care. So we are covered when it comes to constitutionally whether the procedure is acceptable or not. Thank you, Chair.
Okay, thank you very much, Liz. You did a very sterling work in terms of meeting and agree upon on these processes and also the way that we should follow. Can we then, can we get to the next item of deliberations by honorable members? And Honorable Masango.
Thank you, Chair.
and Honorable Stock.
Thank you, Chair. I think I need to thank the department for the presentation and the Parliament legal advisors for the procedural explanation that has gone through. I just want to know if this is the time where one has to indicate which of the clauses or sections that one believes are relevant for the foster care part of the legal solution at this stage, Chair. Is this when we say that? Is that when we indicate that for deliberation? Okay, if that is the,
Okay. Maybe you have to repeat yourself, Advocate Mchengan.
no, I just wanted to know that.
Okay, that one, that part. You seem to have understood it now. Okay.
I wanted to know if that's when one indicates which parts are not in the small bill, in the foster care bill. This is now.
Yes,
Okay.
that's exactly the time for us to express whether do we agree or we don't agree on this. And it's Nabetu. Yes.
Okay, thank you, Chair. So I have just 3 parts that I would like the legal advisors to lead us to sort of engage on why they are not part of this foster care version of the bill. The first one being the definition of orphan, which I believe was section 1. And the second one being the parental rights and responsibilities of unmarried fathers, which I believe was section 21. And then the third one being the devolving of the jurisdiction to children. Those, Chair, are the ones I would like to find out if they can be included, because one believes that they are directly sort of relevant to the foster care. And of course, they are part of the comprehensive legal solution, if one may call it that, but in a more intimate sort of fashion to this bill that we are now working on. Thank you, Chair.
Thank you, Honorable Bridget. Can we give over to Honorable Stock?
Thank you very much, Honorable Chairperson. Let me also join the queue by also appreciating the good work that has been done by our support staff, as well as the parliamentary legal and the departmental legal advisors. I think it was a lengthy process for us, and all of us will agree at some point we're dealing with back through our legal advisors and say, these are the focus areas that we need to prioritize in terms of the legal solution. And I think we really appreciate it as members of parliament where we are. We need to say it's good work in progress. So this is where we are in terms of the 12 clauses. We are like we agreed in the last meeting. And I want to also add my voice to what my colleague, Honorable Masango, has said, apart from some few concerns which he was raising. I also want to agree that the 12 clauses which are put before us are actually very sound and actually foster care related. So we need to consider them. So from a point, say, the work that has been done from the stakeholders' point of view, from the departmental point of view, in terms of the amendments, the definitions, I also want to align myself and agree with those amendments that have been proposed in the bill. And I want to say it's good work in progress for us. So I really appreciate that we are actually getting somewhere, Honorable Chairperson, in terms of the work of the committee. Thank you very much. I agree with the recommendations and the amended proposal.
Thank you very much, Honorable Stock. Can we then give over to Honorable Mangani Jane and Honorable Alex and Fundameva? Okay.
Thank you very much, Chair. And then I must also echo my voice to add on what the other honorable members have already alluded to. I think the team have done a good work, because last time when we deliberate, we said, hey, it was very much confusing, but we come to terms with it and say, go and do 1, 2, 3. And then it's what they have done, what we have requested them to do. So we must really appreciate that they didn't deviate from what we have said, go and do. So I also agree with honorable members who have spoken before me. Apart from the clarity, I do really appreciate the good work that you have done to us. It's very much easy. We can also, when we go out and clarify to people who were not part and parcel, to tell them more about the bill. If I can remind ourselves, we said we are going to deal strictly with those amendments that is pertaining foster care. The others, we didn't put it in the dustbin. We are going to do it. All the submission that we have gone through, the public hearing, will take it when we do the second amendment. Thank you very much.
Thank you very much, Honorable Fan. No, one can. No, not Opperman, Fundamev.
Thank you very much, Chairperson. Is it my opportunity now?
Yes, it's your opportunity.
Thank you very much. Thank you very much, Chairperson. And let me also agree with my colleagues to thank our legal advisors and the department, and in particular the parliamentary legal advisor, for guiding us and for setting out the process going forward. I would also just like to make a few suggestions, largely in support of what the Honorable Masango had raised. First and foremost, 1Q has fallen off, which is the definition of an orphan child, which I would like for us to consider to re-include. Then as well, I think also we need a discussion around 1E, which was the submission by Mr. Van Niekerk. It's only Mr. Van Niekerk that made that submission, and that submission of his has got wide-ranging implications. So it would be my view as a committee that we should possibly reject 1E, because we could always defer that for the second bill process, because we would need to seek public comments on that proposal that he made, which is far-ranging. Then I would agree with Honorable Masango that we need to look at Section 21. Section 21 wasn't the full bill, and all the submissions agreed with it, but it's not in the current matrix that we're dealing with. And why it's important is that many abandoned and orphan children live with unmarried fathers. And therefore, that amendment of Section 21 will help prevent children ending up in foster care. So I think that is an important section that we must re-include or reconsider. And then also to agree with Section 24, which deals with the jurisdiction to hear guardianship. If we don't amend this actually, then the guardianship will remain in the court's hands, or the court will have the only, they will be in charge of that. So those are some of the issues that I wanted to raise, which largely covers what Honorable Masango had said. And hopefully those are some of the issues that we can consider going forward. Thank you, Chairperson.
Thank you, honorable members. And then, according to the process and the procedure, we definitely have to go to clause by clause and say whether we reject or we agree. Can we then take our original bill? This one, ne? Then we are on. We. Oh, but responding with the previous ones, the ones that have. Okay, let's give you department to respond on these ones. See again, close one by one, reject or agree. Masiye kwezi seziraisiwe. The 1E and clause 21.
Yes, Honorable Chair, we will respond. It's just that we thought we are still sorting out
Okay, I
something.
have forgotten to switch on the mic, switch on and off and taking away the mask. It's really a problem to me. We are saying the two honorable members have raised clause 1E and 21. And 24, ne? So we would like you, department, to give us the indication on that. And then after that, so that we can go to clause by clause.
Chair, and 1Q, which was the definition of an orphan child.
One
It fell
Q.
off. Yes.
Oh, yes. Uzindlebe wonke mos. Over to you.
Good day once again, honorable members. We must take into account that we have indicated that there are many clauses in the bill, that is the bigger bill, which we feel may form part of the North Gauteng High Court response. But what we have done as a team is to look at those clauses we feel are closely linked to the North Gauteng High Court order. Not being dismissive of the fact that some of the clauses are also linked. During the presentation,
So which one are not included? Okanye are not in the High Court out of the three that they have raised?
Yeah, it's the definition of an orphan.
Okay.
Yes.
The definition of an orphan.
The definition of
Okay,
an
it's
orphan,
fine.
yes.
Continue.
So the definition of an orphan is not there, not because we are saying it is not linked, but we said we are taking those that are close, we feel are closely linked for the reasons that we advanced, honorable chair, honorable members. But if the committee feels, because this version is not cast in stone, if the committee feels, I mean, there are more clauses that it believes need to be part of the 12 clauses to make them 13, 14, or 15, the parliament is allowed to do so. But for the department, this is how we feel. We felt that the issue of an orphan, yes, the orphan is already defined in the principal legislation, and orphans are already taken into account when it comes to issues of foster care and all that. It's just that we're extending the definition of an orphan to also include an orphan where there is only one parent involved in this particular regard, because the current definition is talking of the two parents having been deceased in order to be. Yes, but there are those who don't have either fathers or mothers, but know only one parent in their lives. So we were taking them into account. So we didn't feel that, I mean, that is closely immediate in terms of dealing with foster care, because the orphans are already there in the foster care system. But if the committee feels that it requires to take that into account, well, we are not opposed to that. Further than that, the issue of parental rights and responsibilities. Yes, indeed, as I indicated during the presentation, that I think I mentioned an example of corporal punishment and the likes, that there are so many clauses when you read the bill or when you read the entire Children's Act, you can say this clause is closely linked to foster care, but the degree of proximity to the response to the North Gauteng High Court is what we focused on, and not that it is not relevant. Yes, we said you can read from clause 1 or section 1 of the Children's Act to the last section, or from clause 1 of the entire bill to the last clause. You will feel that there is some relationship somewhere there, even for adoption as one example that we made. But we said the degree of proximity with regard to this issue, we don't feel that it is immediate, but still it will work in the future. But again, if the committee feels it requires that to be part of this, it is at liberty to do so. With regard to the issue of jurisdiction, I think Honorable Masang, we mentioned that it's clause 24, the amendment of clause 24. We do have it in the matrix. Yes, that is covered. Yes. Okay. We took note of the comments from Honorable Stock and Honorable Lizelle van der Merwe. Again, with regard to the issue of section 21, unmarried fathers, that's what we refer to, that the closer the fathers are to their children, the greater the possibility that they will not be part of the foster care system. So the inclusion of unmarried fathers. But the challenge with that one, we said it still requires, the reason why we don't have it here, it still requires further interrogation and investigation, because sometimes it involves the courts. We cannot just the courts. Clause 21, yes, clause 21. Because the fathers cannot automatically have that kind of a right. It depends on whether they are fit and proper as parents, because some of them, you remember even during the cases of custody in courts, the fathers will not automatically be given custody for one reason or another. Because of that reason, we said this may take us off the rail with regard to this one. So let us not include it in this package. Yes. I hope the department may add some of the things that is more especially from line function, those who are online, if I'm missing anything from what has been asked. Thanks, Honorable Chair.
Excuse me. I had a cramp on my leg. Okay, thank you very much, Advocate Mchochisa. Can we give over to Advocate Mjengane to lead us with the We are Tetas. Okay, let's give over to you again about the process now. Silapha on the deliberations. But before you, let me give also Honorable Opperman, because Mnasen Funungena go agree, not agree, close by close.
Thank you, Chairperson. Before we go to agree, not agree, I want to look quickly at clause 86 that seeks to amend section 159. And in terms of the High Court order, we had to find a long-term solution for foster care as a mechanism for managing foster care orders. Now, in terms of clause 86, when we received the matrix, it was very high level. And after that, the explanations were very high level. So I'd like a summary or clarification for me in layman's terms. What will clause 86, what will it change? We came together to amend the legislation so that the lives on the ground can change for the better. Now, clause 86 will not prevent SASSA from stopping payment on the foster care grant. It will not prevent the expiration of the foster care grant. It will still need to be reinstated. It will still need to be backpaid. It will still lapse. It will not be uninterrupted. So what will the clause actually change? Because everything will stay the same and nothing will change for the person on the ground. Thank you, Chair.
Okay, you are also reminding me of clause 93, I think so, where there is a time frame for the court judgment and also social workers to look after this thing, Mntwana, to be put in the center, or the 90 days. Is it still 90 days? 90 days, it's 3 months, ne? Because you know, the problem with that, most of the time, it takes so long for a social worker or court judgment to finalize the issue, to place a child to a center. Isahleli la 90 days, ne? Hey, ibande man. Mntana de be vulnerable. Can you just explain to the department on that? Njenxane, just get ready to give us ukuthi simele sithini ngoku. Nxamele agree, not agree. Agreed?
Okay, thank you, Honorable Chair. What we are saying as a department in terms of clause 86 is that the position at present is that there has been reluctance in the application of Section 48 of the Act in terms of extending these foster care orders. Section 48 of the Act is already providing for a situation where the courts may extend the order for a period of 6 months. So the power is already there. But what we are saying now in terms of this particular amendment, that it seeks to amend Section 159 by providing that a court may extend an alternative order that has lapsed or make an interim order. So it must be read together with the existence of a clause, that is Section 48 of the Act. There has been that misunderstanding or misapplication or implementation of the two clauses, that when it comes to the extension or a 6 months period, it is already catered for in the broader legislation, that is Section 48. So we feel that by modifying it, by bringing in, say, 159(2)(b), in Section 158, that is in Section 159, we are saying, notwithstanding the amendment to Section 150A, an order placing an orphan or abandoned child in a foster care system in terms of Section 159 before or on the date of this amendment may be extended by the court order in terms of Section 159(2) or Section 159(3). So the implication is that what will happen when this foster care legislation comes into force with regard to existing court orders that are before the courts, and with regard to the whole foster care system. So that's basically the rationale behind the amendment of Section 159. I hope maybe the department may also need to add, so if they are online, the department as in line function, my apologies, Chairperson. That is those who are directly. Yes, I think the Stegiso is there. We'll take care of that. Yes, thanks, Chairperson. Yes.
Over to you. Is it Ms. Stegiso? Over to you.
Good morning, Honorable Chair and Honorable members. Advocate Mchuchisi has clearly outlined, the provisions of this clause 86. And truly, it has been really a struggle in terms of seeing that the presiding officers are implementing the Section 148. And we are saying that no child would really lose a child support grant or not have a valid court order to be in the foster care system if the presiding officers actually extends with that provision that we are proposing now, because it's also one of the areas that we have noticed that it really, puts pressure on the social workers if there is no such extension taking place with this section 159 with the new proposal of clause 86. But as I'm indicating, Honorable Chair, that Advocate Mchuchisi has covered, line function in relation to his responses. Thank you, Honorable Member, Honorable Chair. Thank you.
Thank you, Ms. Chochis. I am just reminded by Mr. Giso whether I am Chochis or Chochisa. What an city Chochis, a colleague. Hi. Okay. Put him Chochis. Okay. Honorable Opperman.
Thank you, Chairperson. I appreciate the explanation of section 48. That
And what
already-
is it saying
that
now?
already contains the clauses of 86. But I want to know, on the ground, while people are waiting while the care grant has lapsed or expired, people are waiting, as the chair said, up to 90 days. What in that 90 days, people are suffering. What will this amendments change? Because amendments are there to change lives for the better. How will it change now? While we still have to wait for 90 days, while we still have to wait for the 3 months to go over. In the meantime, somebody has to take care of that child. How will the lives be changed on the ground?
That one needs a Xokiso between. This guru that we are with, I don't think is going to be able to. But it's the 90 days, even myself, that I was concerned about. Can we give you Polnit?
Thank you, Chair. I'm sitting with exactly the same issue that the Honorable Member has just addressed now, because you get social workers bringing the children to a foster care, parents that is looking after the children in the meantime. When the child gets to that foster care or the parent that is going to look after the child, they come there without anything, clothing, nothing, because the child was just taken away from the parents because of abuse or whatever the case may be. I'm sitting with a case like that right now. 2 children was brought to this lady. The one child is having epilepsy, no food, no clothing, nothing. And it's been 2 months. This lady is looking after the children. She doesn't get any support from anyone because the social workers are saying they are waiting. So like the Honorable Member was saying, is that what can we do in the meantime while we're waiting for the 90 days to expire? Because say the person doesn't have anything and there's no food for the children, how do you take the child to hospital when the child is having epilepsy and all those things? So we need to find out, because the people are asking us on the ground and they want to know from us, what measures can they be taken? Can they go back to social welfare and ask them, look here, is there any way, even if it is maybe giving a food parcel or whatever the case may be, some sort of assistance that can be given to these parents that is looking after the children in the meantime. Thank you, Chair. And thank you for the explanation, because the last time we had a meeting, we were quite confused, but now they've outlined all these clauses and it's much easier to work on them now than before. So I would also want to say thank you to the department and to the people that was working on this. Thank you very much.
Okay, thank you very much. I was about to stop you not to make examples. You can make 5 of them. I know it's really very painful for us as leaders in our communities for that. Ms. Kagis, over to you.
Thank you, Honorable Chairperson. I just need to clarify the timeframes that we have. For temporarily safe care, we say 6 months because it basically prevents the overstay of children in temporarily safe care, which means they are not in approved permanency, which could be either foster care or child and youth care center or adoption. So they will be in temporary safe care for that period of 6 months pending the finalization of the case. But we also have another time frame, which now I hear the honorable members making reference to, which is the 90 days. The 90 days that the honorable members are making reference to, I hope I am correct, that they are referring to the 90 days, which is dedicated for investigations of, those placements which are not yet finalized by courts, because Section 155 of the Children's Act, the Principal Act, makes that provision that social workers have for the 90 days to conduct the investigation and finalize the reports so that courts can make a decision whether a child is in need of care and protection, so that that child could be in foster care or in a child and youth care centers. But in some instances, if the child is in temporarily safe care, the child would then move into, adoption if it's adoption that is pending to be finalized. But when you are in temporarily safe care, you can always approach court, because when we say 6 months, you can always go back to court so that the court can review that court order and extend to say, we understand that you are still waiting for an abridged birth certificate for that determination to say there's no parent available. Therefore, this child really has to be in alternative care. So, Honorable Chairperson, that's why I was saying that I needed to give clarity on these different time frames so that the honorable members understand. But it does not mean that the child will be left without any safety net, because when you're in temporarily safe care, there is a temporarily safe care fee that is allocated so that you can take care of the needs of the child whilst you're in temporarily safe care.
The question, in my understanding, Mr. Kiso, is that in a community, maybe someone gets a child whilst the 90 days hasn't been expired. It's still the case being investigated. That particular person who has managed to keep the child for that period of the investigation, is there anything that might happen during that period of the investigation? That's what I think the question is about. Because myself, I don't have any means to support this kid, but I managed to get this kid and see the situation that this kid is vulnerable in a place. Is there anything that can be done during that period of the 90 days, finalizing the situation and all the cases or whatever that needs to be investigated, the investigation? Mr. Gis, that's the question. I think the honorable members understand the periods, okay, the time due for these different situations. Over to you.
Thank you, Honorable Chairperson. There is a provision, because that child must be with that caregiver in that 90 days period. I think that's why I prefer to talk about the 6 months, because the child can be in temporarily safe care for 6 months, because a child that is in need of care and protection should be in a court-ordered placement to protect anything that could happen to that child. And there is a provision, Honorable Chairperson, that that person that is looking after the child gets the temporarily safe care fee so that the children's needs could be provided for. So this provision is specifically to ensure that no child stays under Neliswa's care without a court order, whether it's a court order of being in temporarily safe care, to protect me or even the child, because the parent where the child is placed, you know, somebody can actually come and fetch that child. So if there's a court order in place, then the temporary safe care fee is placed. And it's not even a longer process, honorable members, because as long as that person is approved as a temporarily safe care person, which is not even a long period, it's immediate, because that child is a child in need of care and protection, but awaiting those investigations to be finalized and the temporarily safe care fee be paid. But I think, you know, from the department side, is just to make those follow up and ensure that the temporarily safe care fee is paid to temporarily safe care parents that are taking care of children whilst they are waiting the finalization of the placement of the child into alternative care.
Okunye ukuthetha okunye ukuthetha ngoba kaloku umbuzo uthi ayikaka lanti kwa by the court, ayikaka approval by the court. So it means laa mntu makenze ubuntu bobuKristu bomsamariya olungileyo. Otherwise there's nothing enokwenzeka or abe nento that she gets or he gets until the court approves it. Yeah, I'm sorry for my language.
Can I?
You follow it? Eh?
I'm making a follow up. Honorable Chairperson, there was a provision which actually found that we're acting unconstitutionally when a child has been identified as a child in need of care and protection and urgently removed and placed in the care of Nelly. So I'll use myself as an example, Honorable Chairperson, and placed in the care of Nelly. So social workers are the ones that are actually putting Nelisiwe into Neliswa's temporarily safe care. Let's say they remove tonight. Tomorrow, I must go to court so that I get that temporarily safe care order. Otherwise, anything can happen to that child who is placed without a temporary court order. Maybe I must use that word. So the following day, so that it really protects that child in that temporarily safe care, and even the parent that is taking care of that child to be able to receive something. So we were found unconstitutional, Honorable Chairperson, to keep children in temporarily safe care without a temporarily a court order. So it's a must that if the child has been removed either with Form 36 and placed in temporary safe care, the following day, the child must go to court so that you've got that temporary safe care order and receive all the support.
Thank you very much for your explanation. It means really people were doing unconstitutional thing. We have to explain these things in our locations and townships and villages. It means they sense into unconstitutional by taking umntwana ahlale naye for weeks or months engekayo reporter a request a court order. Yo, hello xesha lo court uzawufika imini yonke kuyo. All right, honorable members, I can see that your hands are up. Let's start with Jane, Honorable Jane, and Mamu Opperman and Alex. Hello. Polnit, is your hand still up? Oh, you are covered by, okay, thank you very much. Things are becoming clearer and clearer out of this. Thank you. Over to you.
Thank you, Chair. She covered me. I raised my hands. I wanted, even if I'm not a guru, I wanted to clarify this issue because it's what is happening on the ground. Every time, and it means we must, as from today, visit our SASA and social development, because at the ground, when we are at our constituency, I'm always doing that. These answers, you get it clear and then you understand it better when you visited the office. She covered me a lot. Thank you very much.
Yeah. No, also the department must assist us in explaining these things in their offices, because the social workers are the people who are supposed to explain exactly what is it supposed to happen in terms of this. So Jane is right, we'll be assisting in our offices, constituent offices, in our communities, etc. But the department themselves, fanele benze roadshow in terms of this foster care thing in Simayon. Honorable Opperman, thanks, Meche. I saw your hand was up front and even before everyone raises it.
Chair, I'm still not happy. You say there's a safety net and you talk about the provision. But let's go to the lived reality and the lived experience on the ground. You say the next day, you are unemployed, you're impoverished, you do not have transport. Let's go to my town, Louriesfontein. We do not have a walk-in SASSA office. The next court is 270 kilometers away. What is there in place to help me? You talk about the next day. I will never get there the next day. It's 270 kilometers away. There's no SASSA, there's no courts, there's no nothing. You don't have transport and you don't have a job. What do you do and how will this department help me when you talk about safety nets? Thank you.
Alex, yeah.
Thank you, Chairperson. And Chairperson, I'm so happy that we're able to have this discussion. I think it's an important discussion to have, and I'm so happy we are in person to be having, this discussion. Chairperson, and thank you to everybody who's been providing explanations. But just something that I need clarified, because I'm still not, I still don't have clarity on it. So, and this also then touches on the new section that wants that we need to be brought in here 159. So if the court order expires, right? The question I think we all want to answer is, will the child still receive the foster care grant? I think that's the question we want to know. But also with an expired court order, is the social worker still obligated to go and follow up on that child? And with the expired court order, where is the safety net for that child? Because then the grant has stopped, and maybe if SASSA is on this call, they can provide their input. The social worker isn't, obligated to go and check up on that child. And here we're looking at 6 months, 2 years, but the reality is longer than that. And I think we also having two discussions here. We're talking about on the ground, and we can't talk about on the ground if we're not going to have the resources questions, the resources in our courts and the lack of resources in terms of social workers. So I think that's almost a different conversation that we need to have, the resource conversation. But right now we're busy with a legislation conversation. And I think we are going to have a big challenge if we're going to sit here and try to match legislation to resources when we know everything is under-resourced to begin with. So that is going to be the difficulty that we're going to sit with, dear Chairperson. And, as from where I'm sitting in terms of this deliberation, I'm almost wanting to suggest that, maybe we start with the clause that, the first one that we want to amend, so that we get all the less complex ones out of the way, and we can tick them off, and then we can come back to the ones that need more discussion, because we can sit on this expired thing for a very long time, Chairperson. Thank you.
Thank you, Alex. You are right. Knowing exactly the vastness of our areas and the difference or the difficulties that we are experiencing in terms of transporting and getting the social workers around the areas that we stay. It will take us years and years, knowing exactly whether and knowing exactly how difficult it is to get to social workers. Right, Alex, I'm with you in terms of let's park this one and deal with it when we have a departmental meeting in following this. We have agreed according to this clause and amend them. But how are we going to, because people won't even have a time or data to call the call center of looking at this child who has expired into yakhe and don't get the grant. Mr. Uyasiva ne? Ingxaki le. Mr. Uyasiva.
Ewe Honorable Chair, Dianiva, Mama, Dianiva.
On the ground, because we get these challenges and problems in areas and lendo that we are talking about, yes, safety, whatever. Umuntu tomorrow, if you say next day, business social workers. So those are the challenges that we're experiencing. It goes to months and months without reporting it to the magistrate or court or whatever. So we agree, ne? Remember, because it's a fact. But really we can't. Who comes first? Oh, it was you, and then Jane sizodlula kulo clause. Isixoxisile, you know. Okay.
Thank you, Chair. I think
okay. Carry on, ma'am.
Chair, I think it just the part I wanted to come in was to say that there are two stages that we're talking about. The one is when the child is being moved from the street, and the other one is at expiry of the court order, as Honorable Abrams was saying. But also I wanted to link it back to the very reason of us reviewing this bill, to say that it was because of the backlog that was happening at expiry of court orders. So if this clause that we are discussing is the one that is actually going to take care of that, there needs to be clarity or on ensuring that the backlog that we are still sitting with at the moment is gotten rid of in a permanent sort of way. And if it doesn't do that, it just extends the backlog, because that's what it sounds like. It sounds like you have some time still in this backlog, and I don't know that that is the answer and the solution to the problem. Thank you, Chair.
Yeah, thank you. I think the department has noted that. Yeah, it's really extend the backlog and over a backlog, but at a high level, we have managed to explain this and clarify it. And then, oh, Mangat.
At the lower level, Chair, I'm still repeating myself. We have, together with the department, make an awareness, because if the information that somebody is having, majority are not having, it seems children will suffer being kept at home, but not taken to the social development. It seems here we are speaking about two things, because the resources is not what we have put in the bill. So we need, as you said, we need to, when the department are here, we need to have that separate discussion to say, to raise all this frustration or whatever, so that when we departed there, all of us, we must play a role to make sure that community on the ground, they understand what they're supposed to do when they come in terms of these things, together with the social worker on the ground. Thank you.
Very
Chairperson.
much, Honorable Member. Honorable Van der Merwe.
Yeah, Chairperson, sorry, I don't want to delay you. And I think my colleagues have adequately covered all the issues around this. And I think Honorable Opperman and Honorable Abrams spoke very passionately about this. But I want to, in terms of Section 159, I want clarity from the department in terms of what will happen if a child's foster care grant or the foster care order is expired, because the Social Assistance Act does not allow SASSA to pay if the foster care grant order is expired. In other words, this amendment before us, Section 159, only allows them to extend an expired court order retrospectively. So that will not satisfy the requirements of the Social Assistance Act for continued payment. So I needed to understand, just in simple layman's terms, what their explanation is in this regard before we move forward. I understand that we need a separate discussion on these issues, but I wanted to know specifically in terms of this amendment. Please, Chair.
Thank you very much, Honorable Lizelle. But with simple terms, it has been explained. But I will request the Mr. Kiso to repeat again because it's already said. But the only thing that I need is short, Lizelle, is the awareness and information. Because those people that are in centers need to be informed and be told on when there's, the court order is supposed to lapse and needs to be extended. As Honor Ulentukumi Advocate Mchochisa has said, they need to be known or can be told that on how to extend it, because it has been said, and here even in the bill, it's saying that it needs to be extended. Even now, njengoba si busy with the bill, it needs to be extended until i-bill ibe yi-act yenzeke. So I think, Mr. Kiso.
Thank you, Honorable Chairperson.
Yes, fanele ukuthi abantu that are on the ground banikwe information of knowing how to handle the expiry dates and expiry month for extension. Please, khawuphenduleke nje abantu bafe.
Enkosi mama. The proposed amendments in section 159 is to ensure that there is no lapsing of the court order. As we have indicated that it basically reaffirms what is in section 48, where the presiding officers actually are able to extend to ensure that there's no lapsing of the foster care a child grant. So immediately that extension takes place, there won't be any lapsing of the foster child grant should that provision be clearly outlined in section 159. Honorable Chairperson, that's what I just wanted to highlight, to say there won't be a lapsing if the committee accepts, this new provision in terms of section 159 that is proposed by the department.
Okay, I think it's clear now. No lapsing should happen as of now. After the bill. Not all of you guys. For now, it lapses for now. Are you saying so, Mtores? That's what the bill is saying.
No, that's what we are addressing.
Ngokusingekagqibi address izawulapsa. Ndifuna loo ndithi ewe. Okay, Yo, uyayisana nini? Next year. Okay, we need to finish up ne? Because it's going to take time, honorable members. You are right. Okay. All right. Sithini ke ngoku advocate Mjenxa. Sure.
Chairperson, the procedure now would be to.
Okay, before you, isandla sika Meji.
Chair, I was going to say we did understand this bill, what is trying to do, is trying to make sure that lapsing must not happen. That I wanted to say, that's why we must put more effort to make sure that we make sure that this bill ibonilanga. Yeah.
Track the process. We must fast track the process to avoid the lapsing and stop the lapsing. Yeah, libonilanga. Yeah, yes, that terminology, sibonilanga. Mjenxa, Advocate Mjenxa, over to you.
Yes, thank you, Chairperson. So, Chair, the guidance that we would request from the committee is the decision on the clauses as raised by Honorable Masango and Honorable Fana Merve and responded to by the department. So the decision of the committee on that, because that informs our A list. Subsequent to that, Chairperson would then be the process of going through the bill as introduced to deal with the matter of rejecting all these other clauses that form part of that 12, which the committee has now agreed on. That can be done in one of three ways, Chairperson, which is either clause by clause, going through all the clause, as many as 143 of the. So, Chair, that the committee has three choices in doing so, Chair, which the committee can just guide us by giving us a decision. The one option is going clause by clause from clause 1 up to clause 143, or going page by page, which is from page 1 until the last page. Or the last option would be the committee deciding that it wants to go chapter by chapter. What will happen, Chairperson, is that where, if we say go chapter by chapter, where there are surviving clauses in terms of the 12 that the committee has decided to save, we would then indicate in that chapter which of the clauses will be surviving. And then we can just note in our minutes that the decision of the committee is to reject all other clauses which are not surviving in that clause. Thank you, Chair. So the outstanding things are two issues, Chair. Response on the
Court order.
No, the committee decision on the questions by the two members and the responses of the department, as well as which process of the three would the committee would decide on as we go on to amending the bill, Chair. Thank you.
You wandenzela inhloko Mjenxa. Uyamva Stock. Over to you.
No, thank you very much, Honorable Chairperson. I'm not sure if I understood Advocate Mjenxa very correctly, because in terms of my own understanding, I thought the exercise that we have been embarking on as a portfolio committee to allow the legal advisors of both Parliament and Department and then come back and report to us as a portfolio committee and say, these are the clauses that are related to foster care. And then we are not actually rejecting the others, but there will be a separate process in terms of a committee bill that will be able to deal with issues coming out of the public participation process in the public hearings. So I thought, my understanding was that for the purpose of today was for the legal advisors to report back and say, these are the 12 clauses that we're putting before the portfolio committee. And then these clauses, like for an example, Honorable Masango, my colleague here, was raising an issue. Honorable Fana Merve says, we agree with the approach of the 12 clauses, but there are these other issues that we need clarity on. And I think that's what the department was doing now. Now, since that process has been clarified, my understanding is that now we must table the 12 clauses before the portfolio committee. And then we deal with the 12 clauses. The clause by clause relates to the 12 only, not the entire, from number 1 up to the last one. That was my understanding under correction. I'm not sure if I was in order or what, but the legal people, they are here. The committee secretariat are also here, and then members will also be able to express their views and their opinions. I'm not sure.
Okay. All right.
Because if it takes us, sorry, Chairperson, to take you back, if we say we're going to deal with the entire bill clause by clause and decide which one are we rejecting, which one are we putting, and then it will require another session and another session in terms of my understanding. So I submit, Honorable Chair. Thank you very much.
Yeah, let me give Honorable Jane, because even myself, I thought as Honorable Stock has thought, because we haven't dealt with others, we have parked them separately, and we said we'll come back with them. And now we were going to deal with these ones. But please, can you still we thought we'll do clause by clause on these ones that are dealing with foster care. Then the other ones is out, all of them that don't deal with foster care, we are packing them. Or do we have to say we reject even if we didn't discuss them? Honorable J. Sakunika Tatum Chengane and Kabezele Secretary.
Thank you, Chair. I think what we are doing today is what we have agreed upon when we have the meeting to say this, we will only deal with the foster care to address the issue of the High Court. And then after that, we have also agreed that we are not going to say reject. We are going to pack after this. I even said this, it will be the one that we started because we are addressing things that's supposed to be addressed by the fifth administration. Now the one that we have put aside is the one that will deal with it immediately we finish. So today, where members don't wanted the clarity, they can ask the clarity so that we on this that we have said the 12th one, they should be identified. Even the last time when we adjourned, we were having the 12th one, but now it's been giving some meat on it. If we don't, somebody don't wanted the clarity, must get the clarity based on what we have requested for the 12th, not limiting to say people must not have clarity. We must get the clarity.
All right, Honorable Abrams, you'll be the last one.
Yes, Chairperson, just in response to the state law advisor and colleagues, the 12 clauses that we have agreed upon, that's what we'll do clause by clause. But Chairperson, the other question that was asked is whether we consider Honorable Masango and Van der Merwe's input about Section 21, and that's about the unmarried fathers. And I hear that it's not automatic that unmarried fathers gets children, understand that. But if I go back to when we traveled the province, Fathers for Justice was at every one of our public hearings, and those fathers were in tears over their rights as unmarried fathers. And I just think, that as a committee, we should at least include Section 21. That is my view, and I'm putting that to the committee, Chairperson. Thank you.
Chair, my hand was up. I'll be brief.
Lizelle, be brief.
Yes, thank you very much, Chairperson. Now, firstly, I want to concur with you in terms of saying that we should go clause by clause with the 12 clauses. But I want to just remind us that what is before us, these 12 clauses, of course, this now becomes a committee process. So then it becomes our process to say, as much as we accept these 12 clauses, we also want to include or amend. So I would really like to appeal to say to the committee, let's consider including, as Honorable Abrams had said, Section 21, as well as looking at 24, and then also the definition of orphan. At the end of the day, the definition of orphan in this case, which is 1Q. And also I want to say section 21 and 24 in the original matrix was there, it was accepted, there was broad consensus and concurrence on those. So they're not problematic or controversial. So we can include them if the committee agrees, but also to include the definition of orphan, because this bill is about a foster care crisis, and therefore the definition of orphan is critical in my view. But yeah, to support you that we will go through the 12 as agreed clause by clause, but that we also consider as a committee, because it is our bill, to include additional clauses. Thank you, Chair.
Other thing, advocates, both of you, much as we were going to deal with these 12 clauses, including the 21 and 24 and 1Q, when we submit them to the NCOP, are we expected to submit all of them? And before we send these to the court, High Court, the Gauteng High Court, are we supposed to take the big bulk that we're going to discuss, or are we going to take these ones that we were commanded by the High Court? Reason for asking that question, it is because that we agreed as this committee that let's first deal with the High Court request, and then followed by that. Can't we say we are parking those one or disagree, whatever terminology that is being used, if it is the case for the big one? And then with these, the one that you have explained, that how many are they now when we include 21 and 24? How many? They were 12, so it's gonna be 14. 1Q already, we've got one. The only thing we had 1E and 1 whatever. So now 14. I think I've calculated mathematics. I once did, Honorable Masang. So sithini kanye kanye apho khanisincedise bethuna asikwazi ukuthi sihambe nalomqulu close by yonke lento leni. Simane sithi disagree, because we never discuss them. We can't be saying disagree.
No.
For the last, Honorable Masang.
Chairperson, I think of the three options that Mr. Advocate Njengane gave us, we need to make the decision on which one of the three. And I'm inclined to propose that we take the one that deals with chapters, because then we are going to be able to lift what we are living. And then it's not going to take us 443 times to say reject if we take chapters. Yes, thank you, Chair.
Oh, thank you very much. Azikho eyewu izinto. I'm from eyewu, Weekly area. Oh, you know, Ulento Advocate Masango Bridget has given indication of what, let's deal with chapters, and we are interested to show how easy for us to deal with that. Not outstanding this issue of adding those two clauses 21 and 23, and that subsection 1Q. Kanisphendule apho uhleli. Oh. Before that, isandla sikamamanganye simane sivela sitshona ikoni.
I wanted to say we mustn't forget, we know that we did have Fathers for Justice, I agree. We also have those who are still believing in culture, to say umntanam so ilobola sozohambe awukahlawuli awukahlawuleli ukuthi uphule umntanam umlenze. So we must do the balance. I agree what you proposing, but I'm saying we must balance this because we want to address this once and for all. We mustn't, when we are there, the parents come and say, this parliament have sold our children. So we must balance. We must even take time to understand what when we were at the community, what did we hear and understand?
Yeah.
I wanted, I wanted to say that we must bear in mind. Thank you.
I must cut you when I hear you, what you are saying. Uniamvuma Jane is saying that let's balance all the stakeholders that were there. They might be crying that were there. They might not be crying, but we have to also consider all those. You know, I think we are right. Hey, Mufa and Shaker, we are just coming.
Chair,
Sukar.
you don't notice me.
Aye, where are you from, Aris? Wait,
Yes,
we'll give
sis.
Sukars. We'll give you after Sukars.
Chair, I'm obviously coming in the midst of the discussion, but I don't know if it's been concluded in terms of whether we're doing clause by clause or chapters, because it is not, it's for us to decide. Are we doing it clause by clause?
No. Okay, let me
Chapter by
update
chapter.
you.
Okay.
We are on that discussion. The proposal was there of doing chapters by Advocate Masango Bridget. Now, the only thing Jane was doing was trying to make us aware of whether fathers of justice were there or not there, but we have to balance both the fathers of justice and the communities in other areas about this.
Yes.
So the only proposal was that let's do chapters by chapters. It will also assist us in terms of not going page by page of 142 pages. Aris?
Yeah, thank you very much. Chairperson, hey, it seems to me this week got network problems and sometimes I can't hear you, but yes, I can hear now.
Yeah,
I
you
think
have some-
I want to concur with all the previous speakers, Chairperson. What is important to me is, see, I was just thinking, even though my Honorable Jane was saying that we must balance, justice with fathers and this foster care, I don't want a situation where, all the other inputs that we did receive from other community members are not, it sounds not like it is less important. So that is important to me, that if we look at that balance, as much as, the issues of justice of fathers and these critical issues that they have raised are important, all other issues that the communities was raised are important. So I don't want us to see, that justice for fathers, even though they have traveled all the provinces.
Okay, yeah.
You understand what I'm saying?
Yes,
Yeah.
yes.
Thank you.
Thank you
Yes,
very much.
my Janice cover me on that one.
Sukars,
yes.
Sifunu nika advocates, the real ones.
Yes, Chair, I hear you clearly. I just think, I just want to comment that I think the foster care clauses that we're dealing with directly deals with the parental responsibility. And a lot of what was raised in terms of the rights of fathers. So it is not only within the context of only one organization, but it has to do with the weight, balancing the weight of issues that are affecting children that are in foster care and the burden on the state. That is very important for us to consider as we look at these clauses. Chair, thank you.
Okay, they have captured you and they are able to see you clearly in the TV. Thank you very much. We are repeating what Jane and also Aris has just said.
Chair,
Yes,
sorry,
yes.
Chair,
Yeah,
Chair.
very, very.
Sorry, ma'am. Chair, yes, sorry, there's just another thing here. When we consider, because remember that I have raised that issue, and it was an issue that did come out of the public hearings of social fathers, and I don't know if that issue is cleared, and will social fathers be included into what? Will social fathers be included into parents? Will social fathers be included into caregiver, or how will we see social fathers in terms of this legislation? Thank you.
Back when you are taking us back, Simki Lab, we have just passed that and moved away. from
Yeah,
that
Chair,
one.
but you need to
But-
understand that
but,
my network was bad.
Hayi man, yeah, you should have been here. You should be here. Niyayiva le nto ayibuzayo bethu department. Sanuyisabela yolini yamva. Siyedlula ngoku siyahamba nabalifumene iphepha wena.
Uthetha dat ek kan verstaan.
Yeah, you must.
Yeah. You must understand.
Iza mshotshisi mphendule msinyane siyalibaziseka you know.
And thanks, Honorable Chair. Yes, the agreement has been that we are aware that there are so many clauses that have got an impact on foster care, but other clauses have got a problem because they still need thorough investigation before we can have a stand. For example, if we are talking about social fathers, how many social fathers have a direct responsibility in terms of taking care of the children they are fathering socially? We don't have that information. So we can't just assume that all the social fathers are taking care of their children. Same applies as with regard to Section 21. There is so much that still needs to be investigated. As I indicated during the presentation, that it is not automatic that every man takes care of his or her own children, and therefore such children will not form part of the foster care. We still need to investigate that kind of information as a department and as Parliament before we can come to a conclusion that indeed these fathers and over and above that, there are so many role players like the courts, because if we have a provision in law that says fathers must be given that kind of a responsibility, unmarried fathers must be given that kind of a chance, it will be automatic in terms of the provisions of the Act. But the reality is that we are usurping, in a way, the powers of the courts, because the courts will have to still pronounce on the suitability of that particular father, whether that father indeed should play a role in. That's why issues of custody are always contested. They don't come automatically. So what they are proposing is that those issues of custody must be automatically in terms of this legislation, which is a problem. Thank you, Chair.
It's so complicated and it's high level discussions. Social fathers, when you advocate, do you understand what advocate is saying?
Chairperson, can you hear me?
Yes, I hear you.
Oh, okay, yes. I understand what the advocate has said, but that is, remember that most of their children is the only father that they know. And though many of those social fathers are part of their children's life right from day one. That's the issue, Chairperson. And that children don't know any other father, even though there's a biological father. That father is the father that are there mentally, emotionally, financially, whatever. And that people being excluded from
Let
legislation.
me give other honorable members to answer you, because we understand that even the advocate is saying so. But let me give other members to explain for you what we meant when we said it's understandable, we agree, but there's still another process to follow. Can I give Honorable Masango and Honorable Stokes once and for all? We are syllabus.
Yeah.
And my hand is up, Chair.
Chairperson, I just want to come into this Section 21 thing. My take is this, that the bill that was put before us had Section 21. And so my proposal is that we don't consider the more that the Fathers for Justice asked for. We just consider what was tabled, what was publicly heard, and what 90% of the people that made comments agreed with what the department had presented to us. I am saying the Fathers for Justice asked for more than what was there, but they have no problem with it. So let's keep the initial tabled Section 21 that the department tabled. Thank you, Chair.
If I knew what you were going to say, Bridget, I was going to say, hold on there, because there was no need for you to explain this. It's automatically no.
No, it's not. Yeah.
I'm not talking about here. I'm talking about at least in a general knowledge. Maybe let's give stock, but otherwise you have assisted us and also you explained what was asked before. Yeah? Hello? Hello? Sugars? Yeah, because we are together. Yeah. Honorable Masango has assisted us because this question that she is answering right now has been asked in one of the conversations that came up. And I'm saying, ndifuna siphendule this latter one. That's why I'm saying that. Thank you very much for taking us and respond to that one. Honorable Stock?
No, thank you very much, Honorable Chairperson. To be quite honest, without necessarily trying to sound as if I'm being dismissive, I thought our veteran was really assisting us in terms of the way forward. If we can just go back a little bit to what Honorable Mankanyi was saying. Honorable Mankanyi was saying Section 21, which deals with the issues of social justice, fathers for justice, and all of that. We're not disregarding those issues. Those are very critical and very important issues. And also to take it to another level, the advocates, as per their advice to the committee, they are saying to us, look, there are a number of clauses that deals with foster care, because it's not only the 12 clauses that are put before us. But now, honorable members, my colleagues who are dealing now, we're not actually in a rush, but we need to comply with the court order of North Gauteng High Court. So what the legal advisors are saying to us, they are saying for now, in order for us to comply with this legal process, let's deal with the 12. And then we're in compliance with that court order. And then the rest, the issue of father of justice, if I listen to the advocates, they are saying we will have to consult because it's not an automatic thing that is going to happen. The issue of father for justice, for an example, I don't want to sound otherwise, but Honorable Chair, for a lack of a better word, I will say to a certain extent, I'm sympathetic to the issues that we're raising when we were listening to the public hearings. But what the advocates are saying, those issues that are raised will still need consultation to be done, proper consultation, because they cannot just assume, or no, this is what happens, and then therefore they've got a point we need to consider. And then also listening to Mamanganye saying, in other provinces, there are issues of culture and all of that. So if we take Section 21 only and we say we're including it as part of the 12, now a question that will come now, that will arise is, what are we saying about other inputs that we had as well? It will be a debate for another day. And then we'll sit here and debate it, because I will also look at the bill, and then I will also look at my minutes in other provinces. And then I'll say, no, these stakeholders, they've raised this, can you also include it? So we'll end up sitting here now. I think if we are 12 or 15 in the portfolio committee, we'll all say, I've got an additional proposal that I want to make. Can you also consider section what on top of the 12? And now we might end up here, for argument's sake, we're sitting now with 25 clauses or proposals that we need to deal with the amendments. And then others, based on the legal advice that we're getting. And that's what I want to persuade my honorable members, my colleagues, that, I don't think this will be a one-day event for us to deal with the amendment in terms of how I interpret this whole process. So I will actually propose to the meeting, let's deal with the 12 that are here before us. Let's go clause by clause. We deal with clause 1E and H, and then the advocates or maybe the committee secretariat presents it to us. We say whether we agree or we don't agree. We continue like that. And then we take the 12, then we're done. And then maybe in the next portfolio committee meeting, we sit and we say, these are the outstanding ones, let's go through it. And then we identify or embark on a process of a committee bill. Then we deal with all these other outstanding issues. Because I'm just worried, honorable members, remember at the back of our minds, we must take into consideration the issue of the court order, which is going to affect a number of children. And how many times already we went back to court and requested for an extension. That's my submission, honorable members, which I wanted to make. I'm not saying the issues that honorable members are raising, they are not important. Please don't read me wrong on that one. They are very critical, they are very important, including the ones of Honorable Aris, who left the meeting, came back, including issues as well, are also very important. Just for the record, Honorable Chairperson. So I submit, Honorable Chair, let's deal with the 12. And I think let's not go back and forth and back and all of that. Let's take a decision of what we want to do. We deal with the 12 and then we finish with them, or we're going to open the process and put in new proposals, or what is it that we're doing? And I think through your leadership, Chair, will be able to lead us. Thank you very much. I submit, Honorable Chair. Thanks.
Okay, thank you very much, Honorable Stock. You know, this is not really an easy meeting. Fundameve's hand was up before you two honorable members. Can we then, because at the end of the day, I have to take a discretion as a person who's chairing, because I hear you, and I was tabling this of 21 and 24 intentionally to assist the meeting going forward. But honorable members have put it forward. Honorable Fundameve.
Thank you very much, Chairperson. Thank you very much for the opportunity. Yes, I completely hear what the Honorable Stock is saying, but we are not bringing new issues or you know, or speaking specifically about the issues of the Fathers for Justice. Section 21 and 24 was already in the original bill, and there was broad consensus. It came to us from the department. We were going to deal with it anyway in the original bill, and so it was certified. That bill was certified by the state law advisor. So there's nothing contentious. We are simply saying it is our prerogative as a committee to say that, you know, instead of going for 12, we're going for 14 clauses. So I don't think that it's that we're specifically now addressing the issues of certain NGOs or certain groups. We are simply saying in the original bill, those clauses were there. And so we as a committee are exercising our prerogative to say, we also think that those two clauses should be included to make it 14. We're not trying to tinker with them or, you know, to specifically amend them to address a certain group's concern. So that would just be my plea. But, you know, I don't want us to not as a committee also exercise our power to add or delete or abstract, because it is our process after all. So I know we will still be debating these issues further, but that's really my input for now. Thank you, Chair.
There are hands that are up here. Honorable Lizel and Honorable Abrams.
Chairperson, I want to add to what
Honorable Sukar says. So
I want to add to what Honorable Van der Merwe has said. There is a very important aspect to be considered, which is the social impact of the legislation and what the legislation seeks to address. And those three clauses materially deals with the circumstances of children. And so from that, and it goes back to the weighting of a matter. And the weighting of the matter is based on the social impact. So I totally disagree with Honorable Stock in terms of us just chasing for the deadline versus including the material impact that of the children that are living also that the legislation seeks, whose lives the legislation seeks to improve. And so the issue of parental rights are very important because it also materially impacts the children and the state in terms of what the state is responsible for.
I don't want to be seen as a person responding to you. Otherwise, I've got something to respond to what you are saying. Honorable Abram.
Chairperson, just in the interest of taking the meeting forward, I would
Yes,
like to
please.
say that I'm in support of what Honorable Van der Merwe said. I think she put it down good and things. But in the interest of taking the meeting forward, can we not then have a vote on this? 12 clauses versus 14 clauses.
Yeah, there's no need.
Okay. If you say there's no need, but please, Chair, I would like my admitted that I would prefer 14 clauses over the 4 clauses. Thank you.
It's fine. Can we, let's not vote, and we are not going to vote. But gentlemen, when I don't advocate, please, can you split again on this?
Thank you, Honorable Chair. I hear what honorable members are saying. It is quite important, as I indicated from the very first presentation. They include of many other clauses in the bill dealing with foster care. However, the challenges that we may face is that if we are going to, say, for example, agree now to include Section 21, we need to discuss the commentary that we received throughout the country so that we take an informed decision at the end of the day, whether we accept Section 21, the amendment to Section 21 as is, or we accept amendments to Section 21 with modifications based on what people around the country have said. So that is what we need to do. I'm not sure how long it may take us to discuss the commentary that we received throughout the country regarding amendments to Section 21. The other method would be to accept Section 21 amendments as they are in the bill that was advertised for public comments. But the challenge with that one, it will mean that we are disregarding whatever was being said about Section 21 throughout the country. So that is the another, we won't be doing good service to Section 21 amendment, because as I indicate, it will indeed mean that we just took it as it is. Whoever said what about Section 21 throughout the country, we have disregarded that, which is not the good thing to do. Okay, thanks, you.
I'm sure it's the third time that we are explaining that now. Can I give over to the parliamentary advice? And then the last one will be the state law advice on this 21 and 24 only. Masime kaloku with the comments. Uthetha nabani ngoku? Efowunini? Oh.
Thank you, Chair. Chairperson, the decision on whether to include more clauses than the committee has already decided, going beyond the 12 which the committee had agreed, is a matter to be decided by the committee after due deliberation, Chair. The public input in relation to each of the clauses which are now proposed to be included in the amendment must be considered by the committee. The guiding legal principle is that the committee must demonstrate that it's applied its mind to the information before it and make a decision. It is not bound by public input. The committee is not bound to take what came out of the public, but the committee must take a decision having been informed by public input. And therefore, Chairperson, it takes it back to the committee that the committee must...
Sorry, honorable members, this thing of I sometimes do it unintentionally, but let's try and stop it. It also irritates me. Let's wait and listen. What is it that is being said?
Thank you, Chairperson. So in respect of that issue, Chairperson, it is a matter of members taking each other into confidence and deliberating and making a decision on how to proceed in respect of the 2 clauses. And we would then take guidance from that and draft the amendment accordingly, Chairperson. Thank you.
State law advisor, Ms. Liz Naidu, on adding 1 or clause 21 and 24 only, can you also advise us?
Yes, Chair, I'm in agreement with the parliamentary law advisor. It's ultimately the committee's decision. However, when it comes to public comments on clause 21, or sorry, section 21 and this other section, the committee and the department is not bound by what the comments, is not bound by these public comments. All you need to show is that you have meaningfully engaged in these comments and considered it fully, and ultimately the department and the policy of the executive must remain intact. Thank you, Chair.
Okay. The advisors are clear on what they are suggesting to us. I'm giving over the person who is, in fact, Honorable Lizelle and Honorable Alex and Sukers are saying, let's include them, and who else? Aris, and also yourself, Naidu. Now, are you voting counter? Sukers.
Chair.
Yes,
Chair.
Chair, let's if we cannot. Oh
No,
sorry, Chair.
I just want to make, sorry, Chairperson, may I just make a small rebuttal to what was said by the department? Will you allow me? Just one input. The department says that that we should consider what the submissions were in this regard. But I checked back on the matrix, and on the matrix it says 90% of submissions supported Section 21 as tabled. So if we've got 90% of the public supporting Section 21, then I don't understand what the actual issue is, because it wasn't that there were widespread people opposing or negative views. In fact, the matrix said 90% supported Section 1 as tabled. So I just wanted to make that input.
You mean that 90%, at least it's the public comments that allows that Section 21 to be taken as it is?
Yes, correct, Chairperson.
Sure. Then Aris, Honorable Aris.
I agree, Chair, I agree.
You are with Elizelle. Okay.
Yes,
Who
Chair.
else hand is up? Can we agree, honorable members, in taking that Section 21 as it is, as honorable, as Advocate Mchochisa has said? That it means that we're taking Section 21 as it is. Not amended, yes, but we're taking it as it is. As introduced, let me put it as that. Yes, ne? 21 as introduced. Usitsho that umtshotshisi. Yeah, sikulo siqabile ngo-21. 24? Is it the same? How many percent is? How many percentage of the public hearings from the matrix?
I will have to check, but I believe it's the same, Chairperson. There was wide. It says widespread support for S24.
Clause 24 is as it has been put in the bill.
Yes, Chair. Yes, Chair.
Agreed. We are including 24. Sure, 21 and 24 is included. The committee has rescinded its decision of saying 12 clauses have been be looked after or can will be looked at. Now we are, as the committee, introducing the 221, which has 90% of the public hearing, take it as it is, and also the other one, clause 24, as it is, no amendments or other things. Thank you very much. Close the session. And the state law advice. Masidlule, are you still in the same? Okay, okay, let's give Abrams and then give Mangani.
Sorry,
No, we haven't given you. We are giving Alex.
Sorry, Chairperson. My understanding is 24 is already part of the 12. So the 14th one was Honorable Van der Merwe's suggestion of definition Q, orphan. That's the one that needs to be.
It can't be the 14th. It's one, which is included.
Q.
Under one, yes, it's 1, 2. Isn't it?
Yes, Honorable Chair.
So you can't regard, no. Give me a chance. I might take a longer time to explain it. Or you might understand this. We are saying 1, 2 is already included. It was 1E and 1H. Now we are including 1-2, which is a clause 1. Sigqibile. Done. Sipho. Okay, Honorable
No,
Stock.
thank you, Chair. Just quickly, I'm just saying, I'm
Or
happy that we have reached a decision through a consensus, not through voting. I just wanted to put that on the record. Thank you very much.
Yeah, we mustn't always vote for something that is not on the table. We have to discuss and convince one another. Yabo, so vote right through, and we can vote. Sizobovusa nabo Bolankulu from the sickness and also Mutawong from hospital. Okay, Honorable.
I'm up, Chair. I'm up and listening. I'm up and listening. I wanted to get in even now. I heard about that. Thank you.
Okay, Sugars. Uphakamisi or after, okay, excuse veteran. Izaman uyakalala man. Hey. Mama, ubephakamisi lelu. Phakamisa njalo Sugars yamas.
No, Sugars angathunakali.
Thunakala, do you know? Okay, I will explain to you.
You must explain this is your language. You must learn. We've got 13 languages.
By other speakers. You must raise head prior.
Chair, and I'm this person who wanted to understand what the decision that we have taken. We are saying we don't amend section 21. We take as it was in the act, in the previous, including this 24. Thank you.
Thank you, Jane, for understanding so soon. I was about to summarize. Thank you, Jane. You have understood what we meant. Sugars? You are born again.
I'm busy going through the documents. I thought Jane was speaking. No, it is a request, Chair. It's a request that when we are speaking about a specific section, as we deliberate, that section just be brought up so that all members are on the same page. It's just a request that we have it on the screen, yes, so that the whole committee are running together and we're not leaving anybody behind. In that way, we are assuring consensus is reached. And thank you, Chair.
Okay, Fungile has given you a copy, a hard one. Do you have the hard copy because you were out?
We do have it, but it is important that
to flight it. Thank you very much.
Because we are dealing with that we are together.
Okay.
Yeah.
For next time, not for this one. We are done with this one. Thank you very much. We'll do the next time. Please, Lindy, don't forget to flight everything that we have agreed upon. Can we go close by close? Isn't it? Yeah, Emma. Yes. Siyavana ne. 1E, Stedile, do we agree? Yes, Lulango.
Sorry, Chair. Sorry, Chairperson. I think that process we need to really do according to the parliamentary rules and processes. Normally, a decision was taken that you go chapter by chapter. Yes. So normally the legal advisor leads that process, and then he will contrast the smaller bill with foster care amendments, and then show from the bill that was introduced as to where the area is. There will be chapters whereby there are no foster care clauses. On that chapter, we'll say we just reject that chapter as is. So chapters where there are clauses, she will extrapolate and try to explain as to the way 1E is on chapter 1, maybe 83B is on chapter 4 of the bill as introduced. So that is a process. I'll just speak with you,
chapter by chapter. Silapho ngoku. Ngomphi lo advocate.
Thank you, Chairperson. Chairperson, I just wanted to explain quickly the issue of the process. Chair, because this is where the procedural aspects get a bit tricky, especially for interested and affected parties, and have sometimes resulted in litigation against Parliament. So I just want to explain, Chair, and please forgive me if I'm stating something that the committee already knows. The committee is amending the bill as introduced and has taken a decision in terms of the National Assembly Rules 167, which allow the committee to determine its own internal arrangements or internal workings. So the committee has taken a decision that all of those clauses, general clauses, which do not relate to foster care, the committee is going to keep in abeyance for a second amendment process, or will use other legislation making mechanisms that are available to the committee to deal with all of those aspects that don't deal with foster care. Meaning all of the public input that apply to the bill, including those clauses, will be kept in abeyance to follow the process in Rule 279, which of the committee bill, which is a process of a committee bill, to deal with those clauses. So that's a decision. And then on the basis of deliberations on the entire bill, the committee decided to come up with 12 clauses, which have now turned to 13 clauses of the bill. 13, Chair, if we say that the other clause of the definition will be in clause 1. So the committee has taken a decision that only 13 clauses will survive from this bill. Now, we have advised, Chairperson, that there are 3 ways of doing that. It's either we go clause by clause, page by page, or chapter by chapter. Now the decision is to go chapter by chapter. Again, Chair, I just want to emphasize that all that is necessary as the committee decides to determine its own working arrangements is that the committee must demonstrate that it has applied its mind to all of this information when it came to its decision or legally defensible decision of amending the bill in the manner that the committee has decided. So in this regard, Chair, we are now going to be going to chapter by chapter to demonstrate all of those clauses which are rejected in this sense, meaning the technical term of amending this bill and taking those clauses which will not form part of the 12 and keeping them in abeyance and only proceeding with the 12 or 13 which the committee has decided. So I just thought I would clarify that process, Chairperson, just for a better understanding. So, Chair, now we go into the bill as introduced, and I'm hoping that members have copies of the bill in front of them, because we are contrasting from the bill as introduced against the 13 surviving clauses, which the committee has determined. So in chapter 1, Chair, which is a chapter that deals with definitions amongst others, the decision of the committee, Chairperson, is in this regard, is that this chapter will be rejected, and the only surviving clauses will be those clauses which are in the 12 clauses, that is clause 1, A, E, and H, and Q now, Chairperson, in respect of Honorable Fana Merve's input. So, Chair, I'm now putting that chapter before the committee for the committee to vote on it. Chair.
Agreed.
So, Chair, in respect of this,
there is a hand.
Chair.
Masango.
Chair, the 1E, I believe, that speaks to the Mr. Fanikek's submission. We need to I propose that we reject that on the basis that it was not in the bill as introduced, and it has not been subjected to public hearings or public participation. And also it has very far-ranging or wide-ranging implications. So I would propose that we reject it. Thank you, Chair.
Chairperson.
Lizelle?
Yes, Chair, I would like to support the Honorable Masango. Can we reject 1E As it has far-ranging implications, it wasn't subjected to public hearings, and we can always resuscitate that proposal in the second amendment bill. So my proposal is that we reject 1E, please.
What are other members saying? Reject. Honorable Stock.
Thank you very much, Honorable Chairperson. Again, I need to indicate on record for the purpose of record, I'm persuaded by my colleagues on this one that this amendment or this proposal 1E was not subjected to public participation process. So we need to reject it and move forward. I support the proposal, Honorable Chair. Thanks.
Anyone on the platform? No one. So reject. Can we proceed to the next one, Tatum Chenga? Phew, I can't say that to you. It's a mistake, man.
Thank you, Chairperson. So, Chairperson, from my understanding is that the committee has now decided that we're rejecting 1E and taking the rest of the amendment, and that is the final decision of the committee.
Sorry,
Chair.
sorry, Chair, just for clarity purposes, have we included 1Q now as it was tabled in the original bill?
Yes.
Thank you, Chair. Inkosi Kakulu.
Proceed, Advocate.
So, Chairperson, the essence of the committee's decision is that the rest of the clauses are then in line with the committee's decision, kept in abeyance or rejected for the purposes of this amendment period or process. Chair would then have to go to clause 24 of the bill, Chair, which is the amendment of section 25. That's in page 10 of the bill, Chairperson, of the bill as introduced, and page 3 of the 12 clauses. So that's
Proceed.
So in terms of that, Chairperson, that's a surviving clause, which members have decided that must be extrapolated from the bill as introduced and form part of the 12 clauses which are surviving. So if the committee could assist us with a decision on that, Chair, for the record, thank you.
Agreed. Honorable members, Honorable Stock.
Thank you very much, Chair. I agree with the section 24 to be included as part of the amendment. Thanks, Chair.
Chairperson. Okay, I'm just seeking clarity. We're including section 24, not clause 24, just for clarity.
No, sorry. It was just the language. It was just the language. Sorry, it's clause 24 instead of
24.
section 24. Is the Queen's
section
language?
24. Yes,
Yes,
no, sorry.
the
Section 24, not clause 24. Thank you, Chairperson.
Okay.
So,
yeah. No, I thought it's the clause, man. What are we talking about, Kanti?
No,
section.
No, Chair. I made a mistake. Instead of saying clause 24, I said section 24.
Oh,
I think that's
so
what
it's
Liz
clause.
was correcting. It's clause 24.
Hey,
Thanks.
Betun. It's the language kaloku bethunani and siyazibhidanisa ngoku tired.
No, it's section 24, not clause 24. Section 24, not clause 24. Clause 24 deals with something else. It's section 24. I know we are getting mixed up in the terminology, but let the legal advisor just check. It's section 24, not clause 24.
Section 24. So he was right.
So, Chairperson,
No. Wait. Can we give the advocates to assist us on this? Yes. Because there is clause 24. Yes. Now, I hear you were talking about section 24. That's the one that is flighted on the board, which has changed to 2, ne? Is it 2? Clause 2 now. And it's section 45, not what you are saying.
I would like to address you on this thing. I wanted us to listen to each other. When somebody is on the floor we must give that particular person a hearing. And then we must not interject and all of us talking. We are dealing with serious business here. Thank you.
We are dealing with serious business and sensitive issues. Listen to one another, please. Sizwile Mjane. Can we give over to the Guru's department? What are you saying on this? The one of section and the one of clause 24 or section 24?
It's clause 24, amending section 45, Honorable Chair.
So, Sieva Lizel. Lizel, Honorable Lizel.
Sorry,
what
Chair.
was-
Yes, that's correct. That's correct, Chair. Sorry. And yes, it's correct.
Okay, thank you. Can we proceed?
Yes, Chairperson, just to also conclude that, Chairperson, the terminology that is used in this process, Chair, when we are dealing with the bill, we talk about clauses. And then when we talk about the principal act, which is already passed, we talk about sections. So in the bill, we are talking about clause 24, which amends section 25, but the honored member is clarified in that regard. Thank you, Chair.
Honorable Suket.
Yeah, Chair, I'm going to go back because I think there was confusion earlier when we dealt with section 21, I think it was.
We're not
No, we
there
didn't.
yet.
We didn't. Oh, okay.
We're not there yet. We are still on clause 24. Agree or disagree? Agreed. Who is saying agreed? Mjane.
I agree.
Mjane, and seconded by Honorable Masang. Can we proceed on that one from 24 to?
Thank you, Chairperson. So, Chair, now we are on page 24 of the bill as introduced and page 3 of the 12, which we've separated. We are amending clause 56, Chair. We saw this is clause 56, which amends section 105 of the bill. So we're putting that clause before the committee chair for decision. It's clause 56.
Clause 56.
It amends section 105 of the Act, Chair. It reads
105.
section 105 of the Principal Act is hereby amended by the insertion after subsection 5 of the following subsection. The department must develop and conduct a quality assurance process for the evaluation of child protection services as prescribed. Full stop. Thank you, Chair.
Do we agree or disagree? Honorable Stock?
Thank you very much, Honorable Chairperson. I agree on the amendment of section, I think it's section, no, clause 56, which seeks to amend section 105. Thank you.
Clause 56 agreed. Any other people who are disagreeing? Agreed. Thank you very much. Let's pass clause 56.
Chair, we're on page 30 and page 4 of the 12. With the amendment of section 142 of the Act by clause 77 of the bill, Chair. We're putting that before the committee for decision, Chair. Thank you.
Clause 77, section 142. Honorable Bridget.
Sorry, Chair. I think you did say earlier on that we're getting there. Are we still getting to clause 20, section 21?
Yeah.
We are.
I asked the same.
Okay.
Yes. Now we are doing that thing of going clause by clause.
Okay, Chair. Thank you.
Masingathethi sonke, you requested us, Mjane. Now sithetha sonke. Okay. Okay. Clause 77 of section 142 of the Principal Act. Agree or disagree? It has got A, F, B, J, and all other subsection. Sitiniva, agree or disagree? Any hand? Silent means consent according to advocates' language. Nithini bethuni? Khanisincede pha. Kwenzeke ntoni sixingile ngoku?
So Chair, clause 77 is an amendment of section 142 of the Principal Act. In the bill as introduced, it's in page 30 of the bill. It's one of the 12 clauses which have been considered to be surviving clauses that deal with foster care, the ones that were pre-approved by members. So in terms of the principal, in terms of the bill as introduced, it's in page 30, and in the 12 separate clauses in page 4, Chair. I don't know if you want me to read right through it, Chair. So it reads as follows. Amendment of section 142 of the Act, clause 77. Section 142 of the Principal Act is hereby amended. A, by the substitution for paragraph F of the following paragraph. F, prescribing the conditions for the examination of assessment of children who have been abused, abandoned, or neglected, including the consent of the child for any such examination or assessment given the age and maturity of the child. And B, by the deletion of the word "and" at the end of paragraph J and the insertion after paragraph J of the following paragraph. J capital A, prescribing the powers, duties and responsibilities of the Registrar of the National Child Protection Register. J capital B, prescribing the criteria for the establishment and resourcing of designated childcare and protection units, and full stop. Thank you, Chair. So that's our clause 77, amending section 42 of the Principal Act.
Thank you, Honorable Manganya.
Yeah, great, Chair.
Okay, any seconder, honorable members? There's a proposal from Jane Manganya to agree on the proposal. Is there any seconder, honorable members? Then we move to the next one.
I'm supporting, Chair.
Or Honorable Bilang.
Seconding, Chair.
Agreed. Can we move to the next one?
Next one is clause 82, Chair. It's in page 32 of the bill as introduced and page 4 still of the 12 separate clauses. It amends section 150 of the Principal Act. Thank you, Chair. Do you want me to read it out, Chairperson, with your guidance?
Please read it out. Is it what you were proposing, Honorable Sukas?
No, I'm not.
Okay, let's give over to you.
I just want to make sure, Chair, because in the beginning before we started with section 24, I went back to section 21 and I asked the question if we have dealt with it. Am I understanding it correctly that we are going to deal with section 21 after we've dealt with section 24? Am I understanding it correctly?
I think you are absolutely spot on, Honorable Sukas, because section 21 is part of the clauses, all the 13 clauses that we agreed upon as a portfolio committee. So how we are dealing with it now, we will get to it at a later stage. Thank you very much. Over to you, Mr. Jengman.
Thank you, Chair. So we are on clause 82, Chair, which we've put before the committee for a decision. Thank you, Chair.
Please read it out.
My apologies, members and Chairperson. Chair, it reads as follows. Section 150 of the Principal Act is hereby amended. A, by the substitution in subsection 1 for paragraph A of the following paragraph. A, has been abandoned or orphaned and has no parent, guardian, family member or caregiver who is able and suitable to care for that child. Members are reminded that where there are amendments in bold and in brackets, those words are omitted in the amendment. Chair, I proceed to B of 82. By the deletion of the word "or" at the end of subsection 1H. C, by the substitution in subsection 1 for paragraph I of the following paragraph. I is being maltreated, abused, deliberately neglected or degraded by a parent, a caregiver, a person who has parental responsibilities and rights, or a family member of the child, or by a person in whose care the child is. And D, by the insertion after paragraph I of the following paragraphs. J, is an unaccompanied migrant child from another country. K, is a victim of trafficking. Or L, has been sold by a parent, comma, caregiver or guardian, full stop. Thank you, Chair. It's clause 82.
Thank you, honorable members. Can we get proposals? I've noted honorable Honorable Abrams. Over to you.
Chairperson, I just want to pause here quickly and I just want to find out, are we not duplicating, because, you know, definitions of abandoned and orphan children are already there, and then it says there has no parent, guardian, family member. So I just want to find out, so is it necessary to put that has no parent, guardian and family member in the actual clause when it's already covered in definitions?
Okay, it's a clarity seeking question from Honorable Abrams. Can we get a clarity from our legal team? Either Mr. Mjenmane or Chochisa.
Chair, in my view, the repetition of those words does not detract from the meaning of that section. If anything, it adds to the clearer understanding of the section itself. It would be a problem, Chairperson, if it was detracting from the meaning or causing confusion in the interpretation of that section. So words in drafting of legislation are repeated even if defined, if such addition of such words is going to contribute to the better understanding or simplification of the clause itself, Chairperson. So that is my view. So in that regard, there is no repetition because definitions are just for better understanding, whereas here, these words are added for better clarification of the provision of that clause. Thank you, Chair. But I will ask my colleagues to also assist in explanation of on response to that question. Thank you, Chair.
Okay, thank you very much, Mr. Mjenmane. Mr. Chochisa, advocate.
I concur, Chairperson, is for emphasis and clarity, because sometimes you'll find that a child has no parent, not necessarily because a child is orphaned, but has got no parent in maybe because the child has been abandoned or something like that. So it's for clarity purposes, and it does not cause any confusion when it comes to interpretation and reading of the provision.
Oh, okay. So the clarity has been given on the issue raised by Honorable Abrams on the definition, whether it's repetitive or what. So I see the honorable members. Can we get the proposals, or can we give to Honorable Masango? Over to you.
Thank you, Chair. I just want to check something. What is on the screen is the bill as was tabled. It does not have what was proposed by the department. So are we agreeing to the right thing, or we need to agree on the matrixed proposals? I just want to find out this, when we agree here, we agree on what is going to be made act. That does not include the matrixed sort of proposed. Am I making sense, advocate?
Absolutely.
So we're okay. Because the thing is that this is what was proposed, and we just extracted it from the originally submitted bill. And then there was what the advocate used to say, we support this, so the new thing is this. Yeah. Is this the new thing or the old thing?
It's an old thing, through Honorable Chair. It's an old thing.
Yeah. Is that what we're supposed to be doing? Taking the old thing? Agreeing to the old thing?
Yes, can we get clarity, honorable members? Let's get the parliamentary support staff and our legal advisors just to clarify us. I think we're making progress. We're doing very well.
Yes.
Yeah, we're doing very well. let's give to our secretary, Ms. Ntsabo.
And the legal guru will finish off when I started. This is the formal stage of the bill where we consider inputs. The process, I think we're supposed to do it with the matrix to look at whether there were comments that the committee agree on or the department that is in agreement with. So I think it is important to contrast the two documents when we deal with this process. So it was just an omission from to guide you on that. So as is now, which should mean that we agreeing on the bill as introduced, not taking into account the comments that the department agreed on. So I think it's important to contrast with our matrix to go forward. I don't know whether Mjengwa wanted to add anything. Thanks very much, Chair.
Advocate Mjengwa. I think we agree, honorable members, in terms of the approach. The legal advisor, when we deal with a clause, is supposed to be able, like for an example, on clause 82, this is what the clause is all about, and this is what the amendments we are proposing, so that to take into consideration the issue raised by Honorable Masango, because she was getting confused, and I understand why. Because if we put it just like that, it creates an impression we're taking something old, we're putting it here and then say, do we agree on this old thing? Then we're supposed to say yes or no. So if we put it like that, I think we are supposed to be able to say, this is the amendment that we're proposing on this old bill that we are considering. The proposed amendment is the following. I think that's what we all agreed upon, and then we're supposed to do, so that there's no confusion about what is old, what is, because now honorable members are starting to doubt now, are we agreeing on everything? What is it that was considered? What are we supposed to consider? And I think it's a very fundamental issue which we need to consider. I think it covers all our issues, honorable members. So in terms of progress, I will propose we give to Mr. Mjengana, clarify it once and for all, then we deal with the way forward. Or do you want to come in before Mr. Mjengana, Mrs. Sukers, Honorable Sukers?
May I just, Mr. Ngainanya is going to answer on what
yes.
Provide further. Okay, then I'll speak after this one.
Chairperson, thank you, Chairperson. Chairperson, I concur with my colleagues who have provided explanation about this. I must admit, Chairperson, to have made an assumption that members were already cross-referencing all the materials before them in coming to a decision about whether the clause should be amended or should survive as is. Chairperson, I'm relating this to what Honorable Van der Merwe was discussing earlier on, for instance, when she referred to the matrix in response to a clause she was proposing. She cross-referenced clause 24 and was the one who actually pointed out to us that in fact the public input as reflected in the matrix supported clause 24. So my assumption was that as we go on, members are cross-referencing the clause to the information before them, which is the public input, the responses from the department, and then making a decision, which is that issue of showing the application of the mind before we make the reasonable conclusion or decision on each of the clauses that are before members. Thank you, Chair.
Chairperson.
Okay. Who's that? Van der Merwe. Thank you very much, Honorable Stock. I'm back. Thank you very much. I think I hear what needs to be a procedure now. But let's give what to Honorable Van der Merwe and hear what she wants to say.
Thank you very much, Chairperson. I think the issue raised by Honorable Masango is critical, because if we are now saying as a committee that we are agreeing to the bill as tabled, it means that it is nullifying the entire process of the public submissions that we received. So I would have thought that maybe we would have to start this process again and ask our parliamentary legal advisor to read each clause, then ask DST for their response, and then our committee will give our decision, and then that will be the way that we can deal with all of these chapters. Otherwise, if we say we agree to the original bill as tabled, it means we are not taking into consideration the suggestions made by DSD following public submissions. So I would suggest that maybe we would have to start the process afresh, but I don't know. I will take advice from the legal gurus. Thank you.
Sure. Okay. Honorable Sukers, your hand was up.
Yes, it was. It was actually to bring up the point that was now very well articulated by Honorable Van der Merwe, which is the point that I came to the first time. The process cannot run away from the members. And it is important that members be enabled to provide their inputs and apply their minds. And I am concerned that we are progressing, it's true, but we need to make allowance for members to be able to apply themselves to the legislation that is in front of them. And in order to do that, Chair, it is important that if it takes for us to sit here and work it, we must work it. But we cannot let the process run away from even one member that is sitting in this room. It is important that we have it that way. So I want to absolutely ask that all three of these things, the original, together with what DSD has recommended, together what we as members need to consider as public representatives, so that we then come to a decision. And so I support what Honorable Van der Merwe has said.
Hey, okay. Can we then, because we're supposed to go downstairs for 30 minutes, remember kaloku at a hotel, they work with times, and much as I hear honorable members what they are saying, I thought you were saying from where we are, that is clause 82, then it means we have to start afresh. Can I get indication from the advice?
Chairperson, thank you very much. The decision on whether to start afresh, Chairperson, or not is really a decision of members. Where members feel that they had not applied their minds properly, the decision would then have to be logically to go back from the start and start the process de novo. But what we have decided with the legal advisor from the department, Chair, in order to assist and facilitate the process, also to empower members to as they apply themselves to the process, is that I will read the original clause from the bill as introduced, and that the colleague from the department will respond as to what is the view of the department in respect of that clause, and then allow for members to deliberate on it to decide whether they are keeping the clause or they are not keeping the clause. So we hope that that will assist members.
To what the public has said.
Yes, Chair. So which is the process of the
Who
matrix?
is going to go to the public what have said?
So the department has all of that information, Chair.
Okay. Can
Yes.
I request you to go downstairs first and come back at 1:45? And then knowing that we've got a 1 hour to 2:45, because we have to log on to the house plenaries, mini plenaries at 3. Yes, and we have to start afresh as honorable member are suggesting. I see hand.
Sorry, Chair, I will have to leave at 2:30 because we made arrangements for the taxi to pick us up already at 2:30. So I will be leaving at 2:30. Chair. Sorry for that. To the airport, because I thought we will finish by that time. That is what the arrangement
To the
was made.
airport.
Yes.
Oh, I thought you are going to the villages. Yeah, we have to excuse Ulu, Honorable Polnit at 2:30. Even
Okay.
our transport has been arranged for 2:30 to all of us, but we will request them to stay behind until 2:45, 15 minutes after, because we have to at least do a little bit, because here at the hotel they are working with time, so we can't miss their times, and to go down takes another time, and to chew by the honorable.
Chair, sorry, the plenary starts at 2. The first debate starts at 2.
Is it not Wednesday, not today?
Plenary starts at 2.
Izanina, you're sitting here, what do we do with it?
The approval was until 1:30. 2 o'clock because the plenary started 2. That's why I'm busy because
Really,
that's
the
what
two-
we were told.
So what do we do? Because already it's 1:10. And the 2 o'clock is the time for the starting of Lent.
Chair, we can restart next Wednesday.
Physical meeting again, and you are not here.
You will see me next week, no worries.
But our transport is arranged for 2:30. From, because we're still going for a lunch now. Does it mean that we have to adjourn our meeting now?
Yes.
Till next week?
Yes.
And remember, next week it was gonna be the presentation of Lentuka. What was gonna happen next week? But it's another thing next week, according to the program.
It's the first, second, third, and fourth
Quarter.
First financial year.
Yes, it's the budget. But about the first and third, is it not the priority? As in time frames?
Not like more than anything. Legislation.
What are you saying, department?
Was to ask about tomorrow and
Friday, if so members, if
Thursday tomorrow. Caucuses.
Chairperson. Yeah, tomorrow and Friday we've got other
Don't
debates.
use this day. Honorable members, can we be attentive? Tatum Chengani can awulolungu kancinci kame advocate. Can we listen to the program? But Thursdays, we can't utilize Thursdays, honorable members. You know what is happening.
Tomorrow, Chair, which is the 19th of May, there are plenaries in the morning. There's caucus in the morning from 2 to 4:15. There are plenaries that will also resume at 4:30 to 4:45. So tomorrow is full. And Friday, the 20th, there are plenaries from 10 to 12:15. If we intend to meet, it must be 1 o'clock, depending whether Mr. Frolic will approve that.
You?
And then
What time will be that? 12 o'clock?
12:15 tomorrow, your Friday. There are plenaries from 10 to 12:15.
Tuesday, what's happening?
Tuesday, there are members who from this committee who serve in other committees. Member Father Merve and Member Sukers, they are serving, they are meeting on Tuesdays, no? And also Tlongo. So normally the House Chairperson discourage members to sit outside of their allocated slot. On Tuesdays, there's also plenaries from 10 o'clock to 12:15. And the next one is from 2 to 2:15. You're from 2 to 4:15. And then we've got our slots. Wednesdays, plenary only start at 3 o'clock next week, the 25.
So you are saying the first, second, third, and fourth quarters.
Yes, can be deferred. Chair. And then we can maybe, Chair, we can think of doing 2 quarters in one meeting. You can combine.
We have
it,
to do, we can do all of them. Too many meetings, first meeting. We have to. Huh? Yeah, Saturday, Sunday, Friday, out. Masijongeni next Wednesday, the 25th. I've already, my schedule is already put. Oh, yeah. Wednesday next week on the 25th.
Because this deliberation make us to consume more time. We must come a little bit earlier. If we are on video, we must start. Sorry, Chair, not speaking on your mind.
Can we then agree on Wednesday next week, the 25th?
Chair, I was just saying we must start the earlier the better, even if it's next week, Wednesday, because the starting of the time we need to give more time to what we are doing.
For
So
8 o'clock.
let's agree all of us to be the earlier the better, so that we must be able to finish.
9 o'clock is sharp. Siqale 9 o'clock. No delays and excuses. 9 o'clock up until 2:45. Physical or tontoni? Shoo, 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 shoo. Okay. Okay.
This
What are you
issue-
saying? Propose?
No, I was proposing, Chair, that the
Physical.
Physical.
On the 25th.
Yes, we were able to pick up all these things and were able to deal with them immediately.
Okay.
And we're able to process.
Because of time, I have to cut you. You said physical. Anyone against physical?
And you go against, I was saying I'm seconding because
Yes,
this
seconding.
thing of there and
Thank
there
you
is
very
waste
much.
time.
Seconding. Jane has second physical by Masango. Abangekhoyo abakho hey niyasibetha madoda, you know. Kodwa ke sothini mina okay. Physical faki application. We know most what it goes to. Application must go today so as to be approved. Masiyeni ke physical, whether it's touch or what, but it's physical. Okay, thank you very much. The meeting has adjourned.